10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hello, my friends, and thank you so much for coming to spend part of your Wednesday, March 27th with me, 2024. It's a beautiful day here in New York. It's cold still. It's probably still in the 30s. So what's up with that? Hey, Puxatawny Phil, the only guy that gets to keep his job no matter how much he screws it up. Aside from most weather people, I would say. How is everyone today? Did anybody watch last night Surviving the Survivor? I was on Surviving the Survivor last night at about 5 o'clock Eastern, and I posted it late on my community tab. So thank you so very much to those of you who came to support me in the chat. I heard that the chat wasn't very friendly, but through no fault of the host, I must say, because Joel was very kind to me, as were the other panelists, and I thought it was a great show. And you never know what you're going to get when you walk into that type of a situation where you don't know anybody and you've never been on the show before and you don't know the host. But I thought it was a great show. So if you didn't see it, go check it out. I did not read back the chat or watch it back, but I've heard some things that people have told me. And, listen, what are you going to do? Trolls be trolling, right? But you guys know I have the best moderators on YouTube and we don't tolerate it. So this is not the place for that. And if you're here, you probably know that. Oh, Lisa says the chat wasn't bad at all. Okay. I thought it was getting a little crazy before the show even started. And then the mods over there were like, listen, we're not tolerating it. So I did appreciate that so very much that they didn't tolerate it. If you look at the comments, there's, some not great comments about me, but listen, I don't care. I don't care. I am outraged. I am outraged. I really don't care. I really don't understand how there's some people who just have nothing better to do with their lives than to trash me on Twitter in the comments or, I don't know. I don't get it. I just don't get it. If somebody could explain it to me, I will be happily accepting of all explanations for some people who have nothing better to do but tweet all day. Hateful things about people they don't even know. What? Whatever. No big whoop. So here's the thing. What I'd like to do with you today is go over the hearing from yesterday. We're going to watch it together. It's about 17 minutes. That's all it was. 17 minutes. And all I can say is I have a girl crush on Tana Cianetti. I think she was a queen yesterday. I saw a lot of comments that were opposite. I don't know where I saw them. Apparently it was not on a channel that I would watch or that I'm friendly with, but I thought she did a great job. And we're going to talk about it together. They're intimidated. Amy says, it's crazy. They're intimidated of you. It's so funny because Joel, I had never met Joel before. And he said on his show, he said, there's 3 women in the world that I'm afraid of. One is my mother. One is my wife. One is somebody else that I don't recall who he said. And the fourth is now Melanie Little. And I was like, what? I'm a really nice person. What are you talking about? But I think it was in jest. It was in jest. And I took it as a compliment. So look, I'll take all compliments from wherever they come. I'm good with that. And as Maria says, it's nice being back in our own little corner of the bakery, fellow cupcakes. It is. Yes, it is. Thank you so much again, as always, to Maureen Francis for the Cash App tip from yesterday for the what she said was my great appearance on Surviving the Survivor, and also today before the show even started, because she's always the first one in here and she's so supportive, and I just love her so much, and I love you guys so much. And listen, this show is full of love. We're full of love here. We don't tolerate the hate. Why can't we just be lovers, not fight us? Why can't we do that? It's like Twitter is like, I thought about this today. Twitter is like, all right, here's an old Seinfeld reference for those of you who know, Festivus. Remember Festivus? It's true. Twitter is like, for the airing of the grievances. It's like, that's all people do. It's just air their grievances all day long. Wasn't that Festivus? I think it was. All right, so we're going to watch the hearing together, and then we are going to talk about 2 documents that dropped yesterday, from which we are going to learn a lot about what was uncovered by the feds and a lot about the Commonwealth's maybe fear of what's going to happen during the trial of this case. And then, drum roll, please. Judge Cannoni ruled on the motion to dismiss yesterday in writing in a 24-page decision after the hearing. It didn't drop the decision until I think while I was on the show of Surviving the Survivor, so it didn't drop until after 5 p.m. So we're going to go over that decision. And remember, the decision to disqualify the DA in this case, the Norfolk County District Attorney, and for sanctions is still out there. It has not been decided yet. Unless anybody has seen a decision drop today, let me know. Here's Olivia. Olivia. Melanie, can we talk about how Judge Bev literally knows none of the basic facts of the case? Yes, please. Yeah, you know how to reach me. And, if you want to chime in, just toss it in here or reach me another way. And we can talk about the facts and the lack of the facts. And, that's what people were saying about me, that I'm a liar. I'm such a liar. I'm spewing all of these lies. Literally everything that I've discussed with you is in the court file, talked about at the hearings, or in the official documents from this case, the police reports, the witness statements, etc. So those are all lies. Ask yourself who wrote those lies, because it wasn't me. It wasn't me. Like Shaggy used to say, it wasn't me. I'm all full of all the references today. If you know, you know. Shaggy, Festivus, Seinfeld. All right, let's get in here right away before I go off on a comedy routine. And let us together watch yesterday's hearing. Court TV posted it late. It was not live. It was late, but it is more thorough than what we saw on many other channels that were streaming it live because they didn't get the beginning. So for those of you who are just joining today for the first court hearing of the Karen Read case in Norfolk County, Massachusetts, which this courthouse is in Dedham, Mass. This woman to the left here in the black suit is Tanis Yannetti. She's the sister of David Yannetti, who is local counsel for Karen Read. His office is in Massachusetts. And he is the attorney who has to be in court when Alan Jackson and his office, including Ms. Little, who is his associate, who is not related to me in any way, appear in Massachusetts State Court. So just for a little bit of legal mumbo jumbo, a new motion had to be made so that Tanis Yannetti could be the supervising attorney of Alan Jackson and Ms. Little, because in yesterday's hearing, David Yannetti was not able to make it there. And I don't understand why the judge has a problem with that, because look, there are so many hearings in this case that are 10, 15 minutes long. You can't expect everybody to be there all the time. And I saw people also on the cesspool drawing inferences from the fact that he wasn't there and Alan Jackson wasn't there, and there must be this big, they call us conspiracy theorists, or me a conspiracy theorist anyway. There must be a big conspiracy about why they didn't show up and why they made her take the fall, whatever the fall is supposed to be. I don't know. It's crazy out there, you guys. It's crazy. Be careful out there. Wear a raincoat. That's all I can say. Wear a raincoat when you go on Twitter. Okay, here is the hearing yesterday, which began around 9 a.m. Let's listen. I put closed captions on for those of you who cannot always hear the stream, but let me know that you can hear it. The volume should be good on this. Let's go.
I'm Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin. Good morning, Ms. Yannetti.
And good morning, Your Honor. Ian Henke on behalf of Karen Read. Attorney Jackson should be with us on this.
Okay. Good morning, Mr. Henke. Good morning, Mr. Jackson. And good morning, Ms. Reed. All right. So in court, our counsel who will argue the motions for today, and there's only Mr. Henke and Ms. Yannetti. When I set dates on the modified scheduling order, I set dates that were convenient to the parties in recognition of mainly defense counsel's trial schedule.
Okay, she's already mad. She's already mad. She's got it. It's almost like she has to put this on the record. I picked this date because I was, deferring to counsel's trial schedule and blah, 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 blah. I don't know why David Yannetti's not there today. Maybe he had a family emergency. Maybe he's going to I don't know, it's Easter time. I don't know. Maybe, why does it need to be on the record? Like, I did this for them and now they're not even here. And now Ms. Yannetti and Mr. Henke are going to have to argue these motions. Like, okay, they're competent attorneys. They can do it. They can do it, Your Honor. So I guess Alan Jackson wasn't allowed to argue the motion because he wasn't physically present in the courtroom. After the pandemic, or oh my, am I going to get stricken for saying that word? A lot of courtroom rules have changed. Okay, attorneys are allowed to appear by Zoom now. Here in New York, A lot of appearances are done by Zoom now. Attorneys don't even go to court anymore unless it's to pick a jury or for trial. So the fact that it's, it's a motions hearing and he's not allowed to argue because he's on Zoom, I don't know. Why do we got to make a big deal about this? But, it's par for the course, I guess.
And last week I renewed the Pro Hoc Vici motion, but I see Mr. Jackson chose not to be here today, and so counsel will argue the motion here this morning. So
he chose not to be here today. Mr. Jackson is on trial, right? Fairy Raven, thank you. He's on trial in another case in LA. And Your Honor, is it really necessary for Ms. Reed to incur the expense of flying Mr. Jackson here and putting him up in a hotel for a 17-minute hearing? Is it really necessary? What say you? Somebody said in my comments the other day, I like your channel, but the what say you is cringe. And I wrote back, yeah, sadly, I think cringe is worse, but touche. So there you go.
So, but before we begin, I have been told repeatedly from both Mr. Jackson and Mr. Yannetti, and I do understand completely that Mr. Yannetti cannot be here today. He's certainly excused from being here today.
All right, we can excuse Mr. Yannetti, but I love how they say Misty and Eddie twice. So maybe there should be a shirt. Mr. Yannetti is now Misty and Eddie. If you look at the closed captions, it's hilarious.
But I was told that there would be a motion for a motion to dismiss based on egregious government misconduct. I was told that by both Mr. Jackson and Mr. Yannetti. I asked Mr. Yannetti how that motion to dismiss was any different than the motion for sanctions and motion to disqualify the district attorney's office. He assured me that it was in fact different. He assured me that he would put in the body of the motion how it was different. And he assured me as recently as last week that that motion would be filed later that day. So that motion has not been filed. That motion then is waived. So what we have today are two motions regarding Rule 14 obligations. So who's going to argue? Is it Ms. Yannetti or?
I will be arguing.
Okay, so I need you at a microphone. So I will hear you on the motion where you're looking for notes, reports, memoranda, and logs.
Thank you. Your Honor, at the outset, I just want to note that as this court is aware, we have a motion pending before the court to disqualify the Norfolk DA's office from this case. Our position, therefore, is that the DA's office should not be participating in this case or arguing any motions, including this one. And I raise this issue just to alert the court that we are not waiving any objection to their continued involvement in the case.
Okay, so I haven't decided that.
Okay. She's right away. She's preserving the record. Ms. Yannetti, this is what she's doing. She's preserving the record. Love her tone, love her demeanor. She's not taking any nonsense. And look at her. This is a great freeze frame too. I don't know her age. I believe she's very experienced, but I don't know. I like her a lot.
That because I was waiting for the motion for egregious conduct, motion for sanctions, or motion to dismiss based on egregious governmental misconduct, because I needed to be assured that that was different than the motion to disqualify. If I had known it was not coming and maybe no intention of filing it, I would have decided that motion by now.
Okay, I call BS on that, number one. And number two, when you don't get a motion in on the day that you tell someone it has to be in, your clerk usually calls the attorney's office and says, hey, I haven't seen that motion come in yet. Are you going to file it? And they'll either say, oh, no, we're not gonna, or, oh, yeah, it's almost there. We're waiting to e-file it. It's just being, we're putting finishing touches on it or whatever. I still need to sign it or whatever. You waited a week just to announce in open court that you would have decided this motion by now, but you're still waiting for that motion that you told them was due by the close of business that day. Come on now. Let's not be silly. And let's also not forget that her 24-page decision on the motion to dismiss had already been typed up. And rather than tell the parties the outcome of that motion in court, she chose to just file it in the court docket later on in the day. And there's no timestamps. I don't have a timestamp on when that decision came out. I know when, certain papers and outlets picked it up, but on the court docket, it doesn't have a timestamp on it. So we don't know.
Your Honor, it was a strategic decision
Okay.
for us not to file that motion. It's not because it wasn't meritorious. It was a strategic decision
All
only.
right. You made representations that you were, therefore the other motion. I have not acted on that yet.
I just want you
So-
to note the objection, please.
Yeah, the objection's noted. So please move on to the merits
Yes.
of your discovery request.
I love it. I love how she just kept going. I want you to note the objection. I want you to note the objection. Because on the record, the judge has to say on the record, your objection is noted. But she didn't say that. She said, well, I'm still waiting for, I would have decided on this motion already if I knew you weren't going to file it. And no. Your Honor, I just want my objection noted for the record. And then she had to say, it's noted for the record.
Absolutely. Your Honor, we're asking for material that fits squarely within the parameters of Rule 14. Statements were made to investigators in this case, including to Mr. Lally and to his staff, and in certain conversations, the state police were even present. Statements of witnesses are simply discoverable. Although they lodged general objections to each of our requests, and these were really boilerplate objections, the Norfolk DA's office appears to be arguing that these witness statements contained in their notes of their conversations, multiple conversations, are all work product. Neither.
Okay, I think this is a good place to stop because I want to show you exactly what they were looking for because we didn't know what they were looking for. But somehow I got a hold of this document to see what they're looking for. And you're going to see that there's a lot of stuff there that we, the public, and the followers of this case did not know was out there. So let me just pull up their responses so that we can look at them together. And then you're going to get an idea of what they're looking for. Because although we don't have the original, it says it's a response to a motion. I think it may just have been a response to a notice of discovery, but what do I know? So here's what they are objecting to and what they are saying they should not have to turn over because it's attorney work product. See if I can get this a little bit bigger for you. And it's weird because it's a JPEG, so you're going to have to just bear with me on the pulling up of the document and the size of the document and all that good stuff and the pages. Okay. All right. So here is what the response is. And this is what the defense is looking for. And this page doesn't really say too much, but it says here, to the extent the defendant seeks the prosecutor's or advocate's notes, such notes exclusive of statements or exculpatory information constitute work product not covered under the Massachusetts Rules of Criminal Procedure. And then they cite Massachusetts Rule of Criminal Procedure 14A5, quote, this rule does not authorize discovery by a party of those portions of records, reports, correspondence, memoranda, or internal documents of the adverse party or its attorney and legal staff. Just bear with me while I find page 2. They say they should not have to turn over work product. or log materials because not required under discovery rules, and defendants' argument is speculative, and they cite a couple of cases. But here is what they're saying they should not have to turn over, specifically things that the defense has requested based on what they discovered from the feds. Number one, all notes and reports regarding the meeting of Norfolk County District Attorney Adam Lally and victim witness advocate Stephen Nelson conducted with Matthew McCabe, Jennifer McCabe, and Kerry Roberts 3 weeks before Matthew McCabe testified on May 4th, 2023, before the federal grand jury regarding this matter. So we are learning there was a meeting with Adam Lally and this victim witness advocate, Stephen Nelson. I don't know a lot about him. I don't know if any of you do. Matt McCabe, Jennifer McCabe, and Kerry Roberts met with Lally and the victim advocate on May 4th, 2023, 3 weeks before Matt McCabe testified in front of the federal grand jury. Commonwealth is opposing that and saying we don't have to give it up. Number two, all notes and reports regarding telephone calls and meetings conducted by Norfolk County District Attorney Adam Lally with Matthew McCabe, including a meeting which also included Jennifer McCabe, Massachusetts State Police Lieutenant Brian Tully, Trooper Yuri Buchanan, and Michael Proctor, 2 weeks before Matthew McCabe testified on May 4th, 2023, before the federal grand jury regarding this matter. So there was a meeting, again, with Adam Lally, Matthew McCabe, Jennifer McCabe, Tully, Buchanan, and Proctor, 2 weeks before Matthew McCabe testified in front of the federal grand jury. And they are opposing that as well. They don't want to give that up either. And the list goes on. Number three, all notes and reports regarding an interview Norfolk County Assistant District Attorney Adam Lally and victim witness advocate Stephen Nelson conducted with Ryan Nagel in February of 2023. February of 2023 is more than 1 year after Officer John O'Keefe was killed, which was the date of that was January 29th, 2022. February of 2023, 1 year later, Lally, Nelson do an interview with Ryan Nagel. They want the notes for that. Commonwealth objects. Number four, all notes and reports regarding meetings Norfolk County District Attorney Adam Lally conducted with Brian Albert, including at least one that included Nicole Albert, Christopher Albert, and Julie Albert. Speaks for itself, and they oppose that as well. They do not put a date on that. Number five, all notes and reports regarding an interview Norfolk County District Attorney Adam Lally and victim witness advocate Stephen Nelson conducted with Jennifer McCabe, again, undated. Number six, all notes and reports regarding a meeting Norfolk County District Attorney Adam Lally and victim witness advocate Stephen Nelson conducted with Brian Albert and Nicole Albert on April 28th of 2022. Again, objected to. April 28th of 2022, I believe, was around the time that the state grand jury was hearing testimony. Was that before their state grand jury testimony? Not sure. Number seven, all notes and reports regarding a conference call conducted by Norfolk County Assistant District Attorney Adam Lally and victim witness advocate Stephen Nelson with Brian Albert, Nicole Albert, Jennifer McCabe, and or Matthew McCabe prior to July 2023, discussing the fact that they had been subpoenaed to testify before the federal grand jury. We knew about that. We did know about the conference call because that was brought up, I think, during the last hearing, and we discussed it then, and we're going to discuss it again. Number eight, all Canton Police Department event logs regarding the Sally Port Garage on January 29th, 2022. Olivia, I know you're there. You can correct me if I'm wrong, but is that where they towed Karen's Lexus to from Dighton to the Sallyport garage on January 29th, 2022. I believe they want to know what time it got there, perhaps, what time it was logged into evidence, whether it was photographed, what time it was photographed, etc., who was there. What say you? All that kind of stuff. And number 9, all notes, memoranda, and reports regarding interview of Massachusetts State Police Trooper Michael Proctor by Norfolk County Assistant District Attorneys Adam Lally and Lynn Beland, and by Norfolk County District Attorney Michael Morrissey regarding Trooper Proctor's statements regarding the nature of the relationship with the Alberts and or McCabe's, as well as his whereabouts on January 29th of 2022. So it appears that on the date of Officer John O'Keefe's death, Trooper Michael Proctor may have been interviewed by Lally, Beland, and Michael Morrissey regarding Proctor's statements and the nature of his relationships with the Alberts and McCabe's. Oh, wait, it says as well as his whereabouts on January 29th of 2022. It does not say, I correct myself, as I will when I decide that I misread, that this meeting happened on January 29th of 2022, but his whereabouts on January 29th of 2022. They want to know. They want the notes, memoranda, and reports regarding that interview. They don't say when that interview was. So can we assume that interview was done before Norfolk County District Attorney Michael Morrissey gave his what I call hostage video statement that he released to the press? That was not a press conference. It was basically just a video of him saying a whole bunch of stuff about how Karen Reed basically was guilty and that there's no way that anybody else did anything wrong here. And I'm not going to take any questions. And this is unprecedented. And if you haven't watched me before, I have a whole playlist on this case. I think we're up to almost 40 hours of coverage. 40. That's a full work week for some people. 40 hours of coverage on this case. And we went over at length more than once, I think, Michael Morrissey's statement that he gave to the public and to the media right after Judge Cannoni did not grant the Commonwealth's request for a gag order. And we talked about the impropriety of that statement. So apparently, at some point, they all met with Proctor and wanted to know more about his relationship. And unsurprisingly, the Commonwealth is objecting to all of these things, saying they're work product. We don't have to give them to you. And this is what Ms. Yannetti is arguing for in court right now. So I hope that makes more sense to you. Oh, hello, Sean. Hi. Hi, Olivia. Let's hope the feds got that Google fence. Hello, there's Sean McDonough going through the motions. Hello, Sean. Thanks for coming. Let's go back to this hearing now. Hopefully that helps you understand what she is arguing for. And then you're going to hear Lally argue against it. But a lot of the stuff in that document we did not know happened. We now know. Knowledge is power, my friends. Knowledge is power. It's not lies. It's facts. Those things happened. Thank you for coming to my TED Talk.
This court nor we are in a position to judge whether the notes are strictly work product without actually seeing the notes. Work product is defined as legal research, opinions, theories, or conclusions. And to be clear, we are not interested in the Norfolk DA's office's opinions, theories, or conclusions. To the extent that these notes contain work product along with the statements, we are fine with the work product being redacted. We are not interested in their work product, but it is important for us to know whether their notes contain any statements of witnesses. And if they do, they should be turned over to us. Otherwise, discoverable material is not off limits simply because a prosecutor writes something in the margins of a document. That would give an attorney the power to keep otherwise discoverable materials out of the hands of a party who should legally be entitled to see the material. At a minimum, Your Honor, this court should order the Norfolk DA's office to disclose whether its notes contain any statements. They have not disclosed that. If the notes contain any witness statement.
She's right. She's right. Otherwise, every attorney could write something in the margins and claim attorney work product. You can't get your hands on it. We'll talk about that in a minute. It's a little bit different than attorney-client privilege because remember, in this case, Jennifer McCabe, Matt McCabe, Brian Albert, none of these people are represented by the district attorney. They are witnesses in this case. So attorney-client privilege doesn't apply to anything that they said. And in my humble opinion, as an attorney with 30 years experience, granted, I practice in New York and not Massachusetts. And some of your laws up there, my guys, my friends, my Boston friends are a little fugazi, I got to say, a little fugazi. Work product, a lot of these meetings that happened between Lally and these witnesses before they testified in front of the federal grand jury may just reek of impropriety, in my opinion. Although he says that he just was talking to them about what the subpoena meant. It'd be interesting to see if there are any notes and reports, because I thought their defense was going to be, we don't have any notes and reports, but that's not what he says. So let's listen up.
And if the Norfolk DA's office is objecting to producing them to the defense, then we're asking this court to have the DA's office produce those notes to the court so that this court can conduct an in-camera review of their notes and evaluate whether they are truly all work product or whether there is in fact discoverable material contained therein. Beyond that, Your Honor, we would rest on our motion in our brief.
Okay, thank you.
Thank you.
Mr. Lally, your response, please.
Yes, sure. And Your Honor, I'll be brief. So essentially what the defendant's motion seeks is, and I would object to the mischaracterization of every single phone call or conversation with a witness as an interview with a witness, but I'm not even sure what half of these are referring to, as I don't recall any of those specific meetings occurring.
You know who does recall them occurring? The feds. The feds. I don't know. You think there were wiretaps and that's how you know about all this stuff? I don't know. He doesn't recall any of these meetings occurring. So maybe he didn't take any notes. Maybe he doesn't take notes. Maybe he's not a good note taker. I don't know.
But if there were meetings, any meeting with a witness post grand jury was in reference to either harassment that they were sustaining as a result of actions of others in this case, or as a result of a simple explanation as to Rule 17 motions that have been filed for individuals' phones or phone records or other third-party records that they were the subject of. It's a boilerplate response because it's a boilerplate law that applies in this case as far as work product that applies to each and every one of the requests, with the exception of number 8, of which the Commonwealth has no objection to that.
Explain to me how work product applies.
Ooh, putting Lally on the spot for a change. Explain to me how work product applies.
Your Honor, work product applies and specifically in reference to, it's contained within, and I would largely rest on the Commonwealth's motion, but
I'm going to rest on my motion, Your Honor, because I didn't write this response. I really didn't have a chance to read it before I came in, so I'm really not sure. But can I just rest on my papers? Why are you making me talk?
it's contained within what's cited as Beng Sia Lang in regard to interview notes in preparation of testimony is work product under the case law, under the rule of criminal procedure. Whatever notations may be contained within those. But essentially, these are not statements as are defined under.
Look how Tanis Unetti is looking straight ahead, looking at the judge. She's watching the judge for the judge's reaction. She's not watching Mr. Lally at all, which is very interesting.
Rule 14. From any of these conversations with witnesses, Rule 14 doesn't apply to these statements, number one. But secondly, if there is any content.
You just said statements. Doesn't apply to these statements at all. Written statements, oral statements that you took notes about, they're not your clients. These people are not your clients. You should not be prepping them for federal grand jury testimony, sir. Highly improper is putting that mildly.
extent. It's either already been provided through the course of discovery, whether it be contained within a police report, grand jury minutes. There's nothing different than what has already been provided. And then secondly, what the case law states and what Rule 14 states is that these types of conversations with witnesses, whether reduced to writing or not, are within the ambit of the work product doctrine.
All right. Any response? You don't necessarily have to, but I just want to see if you want to.
I would just say, Your Honor, their opposition to our motion does not even acknowledge whether there are statements or not statements. I just heard Mr. Lally say that there in fact are statements. So I am going to ask again that this court take those notes there and go through it and in camera and decide whether in fact all of it is work product or whether there exists within it discoverable materials with statements of witnesses. And I find it hard to believe that there wouldn't be any statements of witnesses concerning this case. Thank you.
Do you want to respond at all?
I mean, let's face it, each one of those witnesses changed their story and their statement at least 3 or 4 times. We've done it. We've done it. We've done the work. We've went over all of their statements together. And then we compared it to what we know about their grand jury testimony. Today, when we read the decision to this motion, we're going to find out about some other grand jury testimony that we didn't know about that flies in the face of the statements they gave at the scene 3 days later, a month later, 9 months later. So yeah, it's very important if he has any notes of those conversations, because again, it could show them altering their statements and adding is mostly what they're doing, adding details that didn't exist before, changing details. It's important.
Your Honor, again, with reference to the, as they term them, interviews, but essentially phone calls with witnesses, these were in regard to explaining to them the Rule 17 process, explaining to them what counsel had filed, what types of records were being requested. It was in large part me talking as far as explaining the law.
I thought he didn't remember any of these things. Now they're phone calls. Now they weren't meetings or interviews. They were phone calls. So I thought he didn't remember. Oh, now he remembers. Oh, yes, they were phone calls. Come on now.
Things of that nature. There were not any statements related to the case or any testimony that was discussed or anything.
And we should just take your word for it because
of that nature. The one thing that I was referring to is there is one request that does deal with a meeting which involves preparation of a witness for grand jury, and whatever that witness indicated in the course of that was testified to before the grand jury. It is contained within the minutes and contained within police report.
Hold on, I got to play that back. Did he just admit that he prepped someone for the federal grand jury? Hold on a second.
In large part, me talking as far as explaining the law and things of that nature. There were not any statements related to the case or any testimony that was discussed or anything of that nature. The one thing that I was referring to is there is one request that does deal with a meeting which involves preparation of a witness for grand jury, and whatever that witness indicated in the course of that was testified to before the grand jury. It is contained within the minutes and contained within police reports of interviews with that same witness.
I'm hoping he means the state grand jury. I'm hoping he's referring to that meeting in 2022 that we asked whether that was before the grand jury. I'm hoping that's what he's talking about.
So there's nothing to report.
All right. All right. The next motion is the Commonwealth's motion for reciprocal discovery. But before we begin with that, Mr. Lally, could you tell me what reciprocal discovery has been provided to the Commonwealth at this point?
Nothing. Absolutely nothing.
Okay, let me explain for you. Reciprocal discovery is automatic discovery. I heard a lot of people like arguing about this in certain cesspools as well. Reciprocal discovery is automatic discovery that the defense is to provide to the Commonwealth. They are not required to provide that reciprocal discovery, meaning experts they intend to call, witnesses they intend to call, reports of experts that they intend to call. regarding whatever their experts are going to testify about, forensic data, the autopsy results, etc. They don't have to turn everything over until the Commonwealth the Commonwealth completes their automatic discovery. Okay. So their obligation time has not started to run yet. Remember, the defense does not need to prove anything in this case. They don't even need to call a witness. If you watch the Adam Montgomery trial in New Hampshire, the defense did not even put on a case. They did not put on one witness. The defense attorney stood up when it was their turn and said, "Your Honor, we rest." Okay, so the defense doesn't need to do a damn thing. They're required to turn over discovery of any experts they intend to call and any witnesses that they intend to call with those reports, but not until the Commonwealth fulfills, that's the word I was looking for, their obligation. And they're not done yet. You're going to hear they just turned over 500 pages to the defense 3 days ago. On the way into court yesterday, they handed Ms. Yannetti a thumb drive. Who knows how much information is on it or what is on it? So the Commonwealth has been dragging their feet for over 2 years. They still don't have lab reports back from Bodie Labs on that DNA from that alleged human hair. And let's see if she's going to now snap at the defense. It's not their turn yet, Your Honor. Hold on. I turned on the stream, but I didn't put it back on the screen for you, and I'm just watching it on my second monitor. Hold on.
Reports of interviews with that same witness.
You tell me what reciprocal discovery has been provided to the Commonwealth at this point?
Nothing. Absolutely nothing.
All right. So trial is 3 weeks from today. When did the Commonwealth provide its certificate?
So the Commonwealth
compliance.
is unable to file its certificate of compliance at this point. The one, I would say, sort of primary piece that we're waiting on is.
Okay. The defense obligation for reciprocal discovery does not start to run until the Commonwealth files their certificate of compliance. And now he's going to abada his way out of why that certificate of compliance is not filed yet. Jennifer says, "I'm so over the harassment coming up from Lally. It's so tired." This is exhausting, you guys. Covering this case and watching these hearings is exhausting, and I agree with you.
There were 2 rounds of DNA testing that were done at the Bodie Lab in Virginia. One of those was completed. That was in regard to the defendant's taillight. That was finished, I think, first week of March, and counsel already has all of that. The second piece.
First week of March. It's only March 27th today, and this trial is supposed to happen in 3 weeks. And they were just provided with the DNA results from the taillight. Beginning of March. Okay.
Is in relation to the hair from the rear of the defendant's vehicle. Just for sort of review purposes, that was something that had gone or undergone sort of typical DNA testing, which is autosomal DNA testing, which is taking the profile from, or attempting to take the profile from the nucleus of the cell, and it relates to essentially both biological parents. That sample was of insufficient quality or quantity to generate a sample under the autosomal.
Scott says, "Exhaustive testing on Alexis Snowbrush horsehair, LOL." Yeah, so we don't know if that horsehair was male or female. So that was undecided and undetermined. So now we're going to move on to the mitochondrial DNA testing, but we're not even sure if the sample is good enough to withstand that. So how did it get on all the shows and all the newspapers that a human hair was found on the taillight? Can someone explain that to me?
So we had asked, and the court had ordered for the mitochondrial DNA testing, which goes to the maternal side only. and the Bodie Lab is able to do that. My latest update from that, and I say all that just to build up as to a sort of caveat as far as the testing is concerned. So the initial estimate as far as the testing was would put us several weeks out. We had asked that it be
Somebody's breathing really heavily into the microphone. It's not me. And I don't know if I can only hear it because I have an earbud in with the sound, but it's like they're going, it's like a heavy breather on what we used to call like a phony phone call, you know, when we all had landlines and people would make phony phone calls, like the heavy breather. I don't know if you can hear it, but I can hear it. It's creepy.
expedited. We had paid for it to be expedited. And the quickest that they can turn around a report would be sometime in mid-April.
The quickest they could turn around a report is sometime in mid-April. So she wants the trial to go April 16th, and the defense is not going to be required to do their reciprocal discovery until after you, Mr. Lally, get back that sample or don't get back that sample or get a report or don't get a report or why haven't you been on the phone with these people like we needed this? He says they paid for expedited testing. I don't see how this trial can go on April 16th. Tell me what you think, because I don't see it.
The caveat to that is whether or not there is a sufficient quantity and quality for them to generate a mitochondrial DNA profile from the sample. That I should have an answer to, I was told, by the end of the month. So hopefully by either the end of this week or very early next week, because obviously if they aren't able to generate a mitochondrial DNA profile from the sample, then there's no reason to generate one from the victim and do a comparison. So that would sort of end it there, and then we would then.
So you haven't even done a comparison with the victim, and yet everybody's out there, and they think I spew lies, right? Everybody's out there spewing. Officer John O'Keefe's hair was found on the taillight of her bumper. It was found embedded in her bumper. It was there. It was there. It was his hair. It's a human hair, and it was there, and as if it's fact. So to those people, I say, watch this. Watch the Commonwealth prosecutor tell you that it has not been proven to be a human hair. It has not even been proven to be a human hair or Officer John O'Keefe's hair. And we don't even know if we're going to be able to get a result back in order to be able to test the victim, to test this hair or fiber or whatever it is. But you can bet that if that Lexus backed into his head like they want you to believe, there'd be more than just one hair there. There wouldn't be so little of a hair that they couldn't even test it. Wouldn't even hold up to testing by one of the most famous and infamous labs in the country, if not the world.
Be able to file the certificate of compliance.
All right. Every other aspect of the case, though?
Every other aspect of the case, as I mentioned, there was a number 8 in the defendant's motion to compel that we should have to them by the end of this week, if not earlier. So
see the power move? See the power move? This is a power move. I was watching some TED Talk and they said that this, either you steeple your hands or you cross your hands in front of you. That's a power move. I love it. Queen Yannetti.
So every other aspect of the case, as far as discovery goes, should be done from the Commonwealth's perspective. And that's the reason that I filed the motion, Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing.
Too bad, so sad. How about this? You didn't provide it. It's not their obligation. Their obligation time has not even started to run yet. And apparently, I guess the judge doesn't understand that either.
Or anything really at all. I'd appreciate being able to get that, review that, or at least see it, prior to the day we're impaneling.
All right. What do you say, counsel?
Your Honor, as you know, we do not owe them any reciprocal discovery until they file a certificate of compliance, which has not been done. I mean, we have received hundreds of pages of documents. I mean, 4 days ago, we received like 400 pages of documents we haven't gone through. Counsel just handed us a thumb drive with, I don't know what's on this thumb drive. We have to go through that. So We haven't given any reciprocal discovery because we are not obligated to do so.
Do you intend to call experts
Yes.
in areas other than DNA?
I'm going to have to defer to Mr. Jackson, who is on Zoom. to
All right,
answer-
but counsel to arguing these motions was to be present here in court today.
Are you freaking kidding me? Are you freaking kidding me? Okay, so counsel, so she's still mad that Alan Jackson, who's on trial in LA, did not get on a flight for this 17-minute hearing. She's going to bring it up again. She's not going to be happy that Mr. Jackson might chime in from the Zoom when they've had so many other Zoom hearings, by the way, and they broadcast this hearing for the world to see on their own Zoom. So tell me if you feel, I know that you feel, because we went over the motion to recuse a couple of shows ago, if you feel that, and I feel this, and so I want to know if you feel this too, that she doesn't like the fact that there's a hotshot lawyer from LA in her courtroom, because every single time there's a hearing, this is the way we do it in Massachusetts. In Massachusetts, we stand. In Massachusetts, you need to get to the mic. He was supposed to be here. It's so like petty. It's just the airing of the grievances. It's Festivus for the rest of us.
Right.
Your Honor, if I can be heard for just a second on that issue, Mr. Lally made it very clear that given the fact that he was not in compliance with his discovery obligations, that this motion was not to be heard today. So this is sort of coming out of nowhere.
No. Hold on. So Mr. Lally doesn't decide what motions were to be argued. Today was for all non-evidentiary pretrial motions were to be argued.
Hold on. No. Jackson said Lally told us we weren't arguing this today because they have not complied with their obligations. And wow, just wow. I mean, this is must-see TV. I'm sorry that it's taken us 52 minutes to get through a 17-minute hearing, but I cannot stop talking about this. No. Yes, sounds like a bad parent, right? It's like something you would say to your kid. No. I said you were not going to Adventureland until you clean your room and make your bed. No.
This was filed timely. This was on for today. If you feel that you cannot argue it, that's a different story. So you are muted. All right. Mr. Jackson, you're muted.
I don't know how I got muted. Yes, we are intending to call experts, and there are going to be experts that are in areas other than DNA as well.
He doesn't need to tell you who he's going to call right now, okay? He doesn't need to tell you that, because who he's going to call is a strategic decision based upon what the Commonwealth turns over and what they're obliged to turn over. So if they are not able to get a hit on that Bodie Labs alleged hair or fiber from a snow brush that they are trying to test, he's not going to need an expert to come in and testify about that. So how about you just say, how long do you think your side of the trial is going to take? Because really that's all she needs to know. Of course they're going to call experts. Well, you think they're not going to call experts? You think that nobody knows that's been following this case that these cellular forensics are going to be a big deal? And the DNA is going to be a big deal. Come on. And the chain of custody is going to be a big deal. And there could be experts on that. Investigative experts who are going to come in, accident reconstructionists who are going to come in and say that, like the FBI, 3 PhD accident reconstructionists testified, John O'Keefe was not hit by a car and a car did not hit Officer John O'Keefe. Of course there's going to be experts, Your Honor. What do you think this is?
But we haven't provided discovery because we don't even know what the 400 pages or 500 pages that we just got 3 or 4 days ago include, nor the discovery that was handed to us this morning. As soon as the Commonwealth gets finished with their compliance obligations, we will then comply with our discovery obligations. We have every intention of doing so, and we're fully prepared to do so. We're waiting on them.
So one,
He does not like that the judge just dissed his sister. Do you get that from him? He's like, I'm sticking up. I'm going to assume she's his little sister. I'm going to stick up for my little sister. How dare you speak to her that way? That was just a little disrespectful.
once you get it from the Commonwealth, you can have it in a matter of a day or so, other than the DNA.
A day or so? Really? Once they give you the final results, you can have all that for me in a day? Or did she really just say in a day or so? This is so mind-numbing to me, coming from a place like New York, where we know all about corruption, by the way, because our DA, I'm from Long Island, as you know, the DA of Suffolk County, Tom Spota, is still sitting in Club Fed or federal prison for some misconduct that happened during his tenure as the Suffolk County DA. Look it up, Spota, S-P-O-T-A. So yeah, once they give you those results from Bodhi Lab, you can have all your expert disclosures to me within a day.
Well, I don't know if I can do it in a day, but
Well,
once we have full
You do know, if you're calling witnesses, you know who you're calling, correct?
I have an idea who I'm.
You're right. Sorry. It's Yannetti's sister, not Jackson's sister. Yes. Sorry. I misspoke. But I think so. He's like mad that she dissed Yannetti's little sister. Let's put it that way. Thank you, Robin. Because it would have bothered me later if I went back to watch this stream and realized how I misspoke. But I'm sure Yannetti on the replay is like, how dare you speak to my sister that way?
Calling, yes.
All right. And you've engaged experts, so you've been working with experts, so you should have all that information ready to disclose, correct?
We're in the process of getting those decisions finalized, yes, but some of them are going to be predicated on what the Commonwealth discovery and the totality of the Commonwealth discovery looks like.
No,
I mean, that's their obligation.
No, I understand. All right, but you will be calling witnesses and you will be calling expert witnesses?
Absolutely.
All right. What is your estimate as to how long this case will take to try?
I assume if the Commonwealth case, I'm just throwing a dart at a dartboard, but based on what I know, if the Commonwealth case takes 3 to 4 weeks, I think our case would probably take 2 weeks.
Okay. All right. Mr. Lally, I suggest that you get that information as soon as possible. It could be that I strike it, but I would hear from the defense on that as well. But
Could be that I strike it. How about this? If you're not going to be able to turn this over within my timetable, this trial is not happening on April 16th unless I strike it. So I'm going to say that even if you get those results back, it's not coming in. It's not coming in. And you know what? That would give Lally's team an easier out than having it come back and say, this is not a human hair. This is not John O'Keefe's hair, and or we can't test it, which we all know that's probably what the results are going to be, because anybody who's been following this case that has half a sense of a logical thought in their brain can probably figure that out. Hi, Tom CPU.
but at least find out if they're able to do the testing.
Yeah, sure.
All right.
Yeah, sure.
All right. Thank you. You have your next date. We'll see you then.
Yeah, okay. That like gives me like anxiety and high blood pressure and all the things, because it strains credulity. It strains credulity. It really does. I don't know. Thank you to Justin Green for the Cash App. Appreciate you so much. Who says my favorite site to learn about Karen Reed. I appreciate you. Thank you so much, Justin. Let's take to some of the comments here. Buzzing for Truth, thank you so much for your super chat. You were great last night. Thank you so much. You never know what you're going to get if you go on someone else's show, so I'm very lucky. Shari Davis, thank you so much for gifting 5 memberships. You are so very generous all the time. Lisa, thanks for being a member for 1 month. Lisa C, proud to be part of your brilliant channel. Thank you. Appreciate that. I really do. Tiffany, thanks so much for your super chat. Says they will prevail. It's only a matter of time. If there was nothing to hide, why delete searches and phone calls while others claim butt dials? This is a disgrace to law enforcement. A lot of us here agree with you. A lot of other people think when I talk about that stuff, I'm just making up lies. So go figure. Kylie H. Trial is quickly approaching. Seems like she sits on every motion forever before deciding. Yeah, we went over that the other day when we looked at the old motion to recuse, that some motions had been sitting out there for 72 days as of the hearing of that motion and still were not decided. P. Lola's mom, you and Brandy Churchwell have done a wonderful deep dives to give us facts, no bias. I'm so appreciative of what you bring to the table. Thank you so much. Brandy and I have been speaking, and we are in talks to get together and do something together very soon. We both have very busy schedules, and so it's a crazy week. It's Easter this weekend, and then spring break, and kids are off. So we're hopefully trying to get something together for next week. So I will keep you posted on that. But thank you. Lissa says, Sean made a good point yesterday. There's a reason why all of a sudden the Commonwealth is saying there were 13 people at 34 Fairview, not 11. They were confronted with the geofence data. Sean's got a lot of good information. And yeah, let's just say probably. Hi, Olivia. Olivia says, Melanie, they know about those conference calls and the existence of notes because they had them on wiretaps, in my opinion, right? That's what I was saying too. Boston, Mass, 781. Chris went right to Lank after this fight. Chris and Lank had each other's back then, and they have each other's back now. Bev referencing Tim Albert instead of Chris doesn't fully explain the relationship. Kirk 71, he let the court believe it was just the hair. Now he claims it was the taillight, which he has already announced has John's DNA on it weeks ago. The lab would know day one the sample wasn't big. Thanks, Kirks, for that. I know that you've been following this case very, very closely as well. Yeah. So there's that. And I think we learned some stuff, right? We learned some stuff. And then after court, the defense made a motion. I mean, the prosecution made a motion. The Commonwealth, they made a motion. They would like the court to direct that during the trial of this case, the court invoke a 500-foot buffer zone around the courthouse that nobody would be allowed into other than the jurors and the attorneys that were coming into court. 500 feet. That's larger than a football field. Football field is 100 yards, right? 300 feet. Football field and a half. Let's take a quick look at that motion because I've never seen anything like this before in my life. I said this last night on Surviving the Survivor. I said, this is like, first thing I say to myself is free speech. And they want to invoke a dress code of sorts. People were curious about my title where it said dress code. I'll tell you what it says. Let's see what we can do here about this sizing. Okay, this is the Commonwealth's motion for a buffer zone surrounding Norfolk Superior Court and request for order prohibiting signs or clothing in favor of either party or law enforcement. This was filed yesterday after 3 p.m., which is why we didn't hear about it during the motions hearing. Commonwealth respectfully removes that this honorable court established a buffer zone around the Norfolk Superior Courthouse in Dedham during the trial in this case. This case has been the subject of substantial media coverage. There have been demonstrations on the sidewalks in front of the courthouse, on the courthouse stairs, on the stairs and sidewalks in front of the Registry of Deeds, and instances of individuals confronting and following potential trial witnesses to and from their vehicles for appearances at court proceedings. During these demonstrations, individuals often carry free Karen Read signs or posters with their interpretation of the evidence. Individuals have also amplified their voices with bullhorns to yell at potential witnesses or promote their theory of the case. The demonstrations also feature individuals and animals wearing free Karen Read or similarly messaged clothing. There is a substantial risk to both the defendant and Commonwealth's rights to a fair trial that would be jeopardized if prospective jurors are exposed to the messages contained in demonstrations, especially before this court has had the opportunity to instruct trial jurors about their obligations to remain fair and unbiased. Further picketing and demonstrating at the courthouse during the pendency of the case would expose jurors to extraneous matter that could, let's bring up this next page. I think somebody did post a picture of like a dog wearing like a free Karen Reed sweater somewhere. Where did I see that? Maybe on the cesspool or something? I don't know. Oh my. You just can't make this up. Come on. Come over here where I can read you, please. It may expose jurors to extraneous matter that could prejudice both parties. Citing some case law. Commonwealth v. Louder, Lowder, which they cite for the premise the Commonwealth, as well as a criminal defendant, has the right to a fair trial. Then they cite this general chapter law, section 268, 13A, which is the picketing law in Massachusetts, which apparently reads, whoever, with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building or residence occupied or used by such a judge, juror, witness, or court officer, shall be punished by a fine of not more than $5,000 or imprisonment for not more than 1 year or both. Nothing in this section shall interfere with or prevent the exercise by any court of the Commonwealth or its power to punish for contempt. So they also want the court to post signs with this law all around the courthouse prominently immediately before April 16th and during the pendency of the trial to notify any persons who are planning to picket, parade, or attempt to influence jurors or otherwise impede, interfere, or obstruct the administration of justice, have actual notice of the possibility of prosecution for such actions. Furthermore, they're requesting an order prohibiting any individuals from demonstrating in any manner, including carrying signs or posters or making statements about the defendant, law enforcement, the Norfolk County District Attorney's Office, potential witnesses, or the evidence within 500 feet of the courthouse, which includes the parking area behind the Registry of Deeds building during the trial of this case. See attached map. I don't have the map, but I've seen the map and it's out there. And so they actually have a map of where they want this buffer zone to be. They also move for an order prohibiting anywhere where prospective jurors gather or walk to the courtroom the wearing or carrying of papers, water bottles, tote bags, signs, buttons, pins, t-shirts, sweatshirts, hats, or any other attire or item that contains any images or writing that suggest a favorable or unfavorable opinion of either party. Information regarding opinions that members of the public have about this case are irrelevant and may be prejudicial to the Commonwealth and or defendant. Again, my Massachusetts friends, if you see something, say something. Freedom of speech? I could see a reasonable zone, maybe cordon off at the, the side streets and have the people who want to show support or, as you call, protest or wear a button go there. 500 feet is excessive. Further, the Commonwealth requests that this court, I found incredibly interesting. I've never seen this before. They're asking that the court expressly prohibit any individual in the courthouse from wearing any buttons, shirts, or insignia related to the defendant, the victim, and or law enforcement, including a prohibition on law enforcement officers who are testifying or are members of the audience from wearing their department issued uniforms or any police emblems. What? The show I was on last night, Surviving the Survivor, there was a prosecutor from Georgia, Fulton County, coincidentally, talking about Fonnie Willis. I saw somebody mention Fonnie Willis before. And he and I were on, kind of different sides about this case. I don't know that he knows as much about this case as I do, but that's cool. He was respectfully disagreeing with me. And he said, are you kidding me? He's like, as a prosecutor, I would want my law enforcement witnesses to come in uniform because they're going to have a little more credibility when they show up in the uniform. Is that what you're saying? Hey, Turtle Boy Live. That's actually common about cops not showing up for these hearings, but actually common about cops, but no cops show up for these hearings anyway. This prosecutor from Georgia was like, we want them in uniform when they're on the stand because it gives them more credibility. Then Lally says, to the extent that the court requires assistance or a specifically articulated mechanism to enforce the proposed buffer zone, the Commonwealth proposes that the court could request assistance from the Dedham Police and or Massachusetts State Police, both who have been previously deployed to maintain security and safety during prior court proceedings. Huh? So now that was the dress code. Like they don't want anybody to be able to, and I'm sure this is going to extend to justice for JJ buttons as well, right? Because those seem to be in favor of the victim. So you can't wear them outside the courthouse. You can't wear them inside the courthouse. You can't be within 500. And that's what they're asking for. Doesn't mean they're going to get it. Doesn't mean they're going to get it. But look, if you've been following this case with me, you see the way that Judge Cannoni's been ruling in this case. I covered a case with Duty Ron. It was the Trezell and Jacqueline West trial out of California, Bakersfield, California. And that rule was invoked that they couldn't wear Justice for the Boys t-shirts into court with pictures of the boys. These two monsters were found guilty, by the way, of killing their two adopted, previously foster children out in California. So I've seen that before. This is a little excessive. A little excessive. Diane says, Dogman does not mention Turtle Boy apparel. That's interesting. Fairy Raven, seriously, everyone just wear Minions clothing. Snowcats Tish says they'll probably get it. H-Bag says, Bev will give it to me. Think 500 feet? I mean, that's really excessive. Maureen says they'll get it. Supermax Captain, free speech seems to be determined by agendas and demographics. Does BLM ever get banned from courthouses? I think not. Wasn't there, and I didn't cover this as a YouTuber, but when the Johnny Depp and Amber Heard trial happened, and it's different because it's a civil case, but still, there was a lot of harassment of people in that case. Wasn't everybody outside the courthouse with signs and wearing t-shirts and buttons? And I think that case was in Virginia, but those of you who did watch that, let me know. She denied the gag order, says Stephanie, so maybe a little hope. Unreasonable Massachusetts, says Darcy. We already know that Massachusetts does not recognize a journalistic privilege. We went over that one stream at length. So that's in one way that they are crazy. Team Brittany, attorney Melanie Little, and even alpacas dressed as pirates. Oh yeah, that's alpacas at the Johnny Depp. Yeah. Thank you, Boston. Wait, hold on. There were llamas. This mama bug. You guys are moving so fast in the chat, but Boston, Mass. 781 says so. An unprecedented public statement from the DA's office on mainstream media doesn't impact jurors. Right. Right. Unprecedented. Kate Lewis, maybe if all the police officers turn up in uniform, they're scared how obvious it looks they're freaking Karen. I don't know. Right. And Jeanette says, yes, in the boys case, this is going back to the West case out of Bakersfield, Kern County. I think that was right. Kern County, California. Nothing inside the courtroom. Right. No justice for the boys, no t-shirts with the boys' pictures on it. Sarah OF, they had them use a back entrance for the Depp Heard case. No ban on people outside. Yes, this is what I was going to say. Why can't they bring the jurors in a back door? There's got to be another entrance to that courthouse. You cordon off an area where the jurors can be dropped off or where the jurors park. Like, I understand, like, people shouldn't be allowed to approach jurors at all. They should be able to come in a separate entrance. That's normally the way it's done. So notice how they're not asking for any protection of, you know, the criminal defendant in this case, that there should be, you know, a special way for her to get into the courthouse. Turtle Boy's back. There's a back entrance. I came through it in shackles. Yeah. So, you know, right? There's another way of doing this. And hopefully, you know, obviously the defense is going to oppose this and say you're going to be trampling on people's First Amendment rights to free speech and all. But apparently, Massachusetts, Massachusetts. It's like almost like some of your laws that were written like during Pilgrim times. No offense to you guys. I love you. I love you with all of my heart. But some of these laws are just crazy. They're just crazy. All right. So since we've done that, thank you, Bob Weir. Bob Weir is in the chat. Bob Weir, look, I was at your show. Look, I was at your show. That's from California, from the forum. Bob Weir says that's what they always do. They just want to overreach like everything else in this case. Yeah. So since we've looked at those two things, let's now take a look, shall we, at the decision on the motion to dismiss, which, you know, we talked about this a lot, and we talked about the fact that I did not think it was going to be granted, and spoiler alert, it was denied. But let's take a look at it together, shall we? We're going to go through it. I've highlighted some pertinent portions. It is about 24 pages to see if you have any questions. There's some new information in here that we're going to glean from this. So I'm reading this not so much as to say this should have been granted. I'm going to tell you what I agree with in the decision and what I don't agree with in the decision. And we're going to look at some of the new information that we're learning that we can glean from this decision, things that we didn't know about, things that were testified to in front of the grand jury. So let's do this, shall we? This was just filed yesterday after court. So she didn't rule on this from the bench, which she could have done because she was not too happy that, you know, Alan Jackson wasn't in the courthouse to argue that nothing motion. Wait, Mandy, hold on. Mandy says, no one will go to Plymouth Rock with me, even though I've never been there because everyone from here went on that disappointing field trip. Oh, I'm sorry. I remember those field trips. We used to go to Ellis Island from here. We go to Ellis Island. I don't even think they ever took us as a class to the Statue of Liberty, but that would have been a cool trip. But yeah, it's funny. Like if you live there, nobody wants to go there. It's kind of like touristy things like, you know, going to the top of the Empire State Building. All right. All right, here we go, my friends. Oh, thank you, Cheryl. I saw this sneak in for here for your $20 super chat. You're the best, and I appreciate you so much, Cheryl Kelleher. Love your input always. Love you, girl. Thanks for watching. All right, here goes we. The memorandum and decision of decision and order on defendant's motion to dismiss. Remember, that motion to disqualify the Norfolk DA and for sanctions is still hanging out there. That's the one she said she would have already decided if she knew they weren't going to file the motion for egregious governmental misconduct. But she didn't have her clerk call him up and say, is it coming? And it's been, what, a week? So I guess we should expect that decision soon then, right? Because this one was already typed up, ready to be filed right after the hearing. So on June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe. It's Officer John O'Keefe. It's Boston Police Officer John O'Keefe. Just going to call them. And this is the court. Okay, I understand when Lally does it because he doesn't want everyone knowing who doesn't know anything about this case that Officer John O'Keefe was a Boston police officer, a brother in blue. Okay, I back the blue 100%, and I know a lot of you guys do too. And I feel like people who are supportive of Karen Reed not hitting Officer John O'Keefe with her car think that we are anti-blue and anti-law enforcement, and nothing could be further from the truth. So tell me in the chat if you also back the blue 100%. Let's remember that the victim in this case, Officer John O'Keefe, is also a brother in blue. And the fact that the court is putting a public decision out there that doesn't even mention the fact that he is also a police officer. Now I am even more offended. I was personally offended before when in the Commonwealth's papers, they never referred to him as an officer. But now that the court is doing this in a public decision, back the blue, Kimberly. Thank you. Bob Weir, of course. Absolutely back the blue. Back the good blue, right? Not all cops are bad, just like not all priests are bad. I handled the Catholic Church cases for the survivors of clergy sex abuse. Not all priests are bad either, but there were a lot of bad ones. And they covered that up. There was a lot of fraud in that case, the Catholic Church case. So, Maureen, I back the blue. Have a family full of them. Yep, everybody's back in the blue here. So, like, really, that's not what this is about. Some of us are Boston PD and stand by Karen 100%. Right, a lot of blue hearts in the chat. Okay, so are you offended that that the court did not refer to her boyfriend, John O'Keefe, as officer? I am. I digress. The defendant is pursuing a third-party culprit defense, arguing that one or more persons attending a social gathering at the home of Boston police officer Brian Albert on January 29th of 22 killed O'Keefe, and that they, along with others, including the Canton and state police, engaged in a cover-up of the crime. Period. Okay, this is the soundbite that every news organization is going to go to. So, Brian Albert is addressed here in the court's decision as a Boston police officer. And every news organization is going to say that Karen Reed is arguing that one or more persons attending a social gathering at the home of Boston police officer Brian Albert on January 29th, 2022 killed O'Keefe, and that they, along with others, including the Canton and state police, engaged in a cover-up of the crime. I don't know that that's exactly the theory, but that's what the media is going to run with. You and I, we've been through this case before with a fine-tooth comb, and like I said last night, again, on that show, there doesn't have to be a whole big cover up. There doesn't have to be a whole lot of people involved in this. Like everyone thinks all these people are in this whole big conspiracy to, no, it doesn't have to be a whole lot of people. It doesn't. It's a couple of people who stick to a story that says John O'Keefe never came in the house. Period. End of story. And then a friendly. So it's really not as hard to believe as some people want you to think. The defendant now moves to dismiss the indictments against her on the grounds that the Commonwealth's presentation of evidence impaired the integrity of the grand jury proceedings. This is the Odell case they talk about all the time. She argues the Commonwealth knowingly and recklessly presented false and deceptive evidence to the grand jury and withheld exculpatory evidence for the purpose of obtaining the indictments. The defendant also argues that the Commonwealth deliberately admitted inadmissible evidence to secure the indictments. On March 12, 2024, the court conducted a non-evidentiary hearing on the defendant's motion to dismiss. The court has carefully reviewed all the grand jury minutes and considered each of the defendant's arguments. Given the extensive evidence supporting the indictments, to the extent that the Commonwealth improperly put before or withheld any evidence from the grand jury, it is unlikely that it affected the outcome of the proceedings. Accordingly, the defendant's motion is denied. Now, I'm going to tell you that what I found interesting about this motion is that she's going to say throughout these 24 pages that, you know, this in and of itself wasn't enough to say that the grand jury would have reached a different conclusion. But she says that about 4 or 5 times. And so when you say that 4 or 5 times, that is the totality of the evidence here. And yeah, maybe not each one by itself could cause them to come to a different outcome. But it is very difficult to overcome something that the grand jury does. And in this case, I didn't think this motion was going to be granted, but the way she explains it, it kind of makes me go, well, yeah, but when you put all these things together, like you're saying, now that we add them all up, aren't you sort of just refuting your own argument here? I don't know. A lot of times when I look at this case, I feel like I'm in the twilight zone. So once again, if you see my cursor on the screen of your television, this is not a fly. This is my cursor. Sorry. That's the only way I can scroll this over here. Okay, so here's the background. And they say, during the grand jury proceedings, the Commonwealth presented evidence of the following. I like to look at the footnotes. So let's take a look at the footnote. The grand jury heard 14 days of testimony from over 40 witnesses and received 56 exhibits. This background section is merely a summary of the Commonwealth's grand jury presentation and is not intended to reflect the entirety of the evidence it presented. So she says she's read all of the grand jury minutes. We have not seen the grand jury minutes. Grand jury proceedings are secret, and the minutes will not be released to the public, likely. But by going through her decision, we're going to see what some of the testimony was. And remember, the grand jury is a one-sided proceeding. It is only the Commonwealth presenting evidence, calling the witnesses that they want to call, eliciting the testimony that they want to elicit. The defendant is not there. Defense counsel is not there. And they're allowed to present whatever case they want. A grand jury, like a Florida jury, like we saw in the Maya Kowalski case, for those of you who followed Maya with me, grand jurors are allowed to ask questions of the witnesses and the prosecution. So we're going to see that some of them did have questions. We don't allow that in New York in regular juries. The Maya case was a civil case. In Florida, the jurors of this civil case had pads and notebooks, and they were allowed to ask questions of the witnesses after the testimony was in. It was crazy. We don't do that here. I don't know if you guys do that in Massachusetts, but I don't think so. And there was a famous judge in New York, Saul Wackler, who was the chief judge of New York Court of Appeals, I believe, who said that a New York prosecutor could get a grand jury to indict a ham sandwich. That's where that comes from. We've talked about that before. All right. Here is the Commonwealth's presentation of the facts as they told the grand jury. Okay. On the night of January 28th, 2022, defendant O'Keefe and a group of friends went to the Waterfall Bar and Grill in Canton, the Waterfall, where the defendant consumed several alcoholic beverages. Shortly after midnight, she drove O'Keefe to the home of Boston police officer Brian Albert, the Albert residence, where a group of people from the bar were meeting. Early in the morning on January 29th, 2022, heavy snow was falling with blizzard-like conditions. Well, that's the evidence that the Commonwealth presented to the grand jury, but we're going to find out in the real trial that no, it was not near blizzard-like conditions at 5 a.m. It just wasn't. Some of you have sent me your own ring footage from that morning showing me from Canton how much snow was on the ground. But that's what they told the grand jury. At 4:53 a.m., O'Keefe's niece called Jennifer McCabe, a friend of O'Keefe's, and told her that she needed to talk to the defendant. Jennifer McCabe had been at the bar with the defendant and O'Keefe the night before and went to the Albert residence afterwards. The defendant was distraught because O'Keefe had not yet come home and was not answering his cell phone. Jennifer McCabe heard the defendant screaming. Okay, remember, this is what Jennifer McCabe testified to in front of the grand jury now, because it's cited right here. This is the page on which you can find it. Jennifer McCabe testified that she heard Karen Reed screaming, quote, "John didn't come home. We had a fight. I left him at the waterfall," end quote. I want you to remember something. Like she said at the beginning of this decision, the grand jury did not indict Karen Reed until June 9th of 2022. So the grand jury met for, she says right in here, 14 days prior to June 9th of 2022. That's when Jen McCabe and all of these other witnesses testified in front of this grand jury. In May of 2022 or April of 2022. I don't know the exact dates, but I do know that some of those things that they want the notes from, some of those meetings occurred before June 9th of 2022 when they were being prepped together. This was a group session, apparently, to testify in front of the grand jury. And you're going to see in here too, it gets better, that Jen McCabe and Carrie Roberts made a chart together, a timeline of events before they testified in front of the grand jury. So the statements that they gave on the date of the incident, January 29th of 2022, and then there were, Jen McCabe called and said, come back, I have some more information for you. I want to give you more. I got to add this to my statement. I got to add in here. I don't know if you guys heard this, but Karen said, I hit him. And they went back and they took that statement from her and added that to her statement. And then they took a couple more statements from her. And then she testifies in front of the grand jury and says this. John didn't come home. We had a fight. I left him at the waterfall. At around 5 a.m., the defendant called Carrie Roberts, whose husband is friends with O'Keefe. Okay, is that true? Carrie Roberts' husband is friends with O'Keefe? I thought Carrie Roberts was a childhood friend of John O'Keefe's, or a friend of his, not her husband is friends with him. I don't know. Somebody, no? We can get back to that. The defendant was hysterical, and she screamed, John's dead, and then hung up. Okay, so this is also in the grand jury transcript. Did Carrie Roberts say? Carrie Roberts is now saying that she said John's dead and then hung up, because we looked at Carrie Roberts' statement that was taken close in time to this incident. Nowhere in Carrie Roberts' statement does it say that. H-Bag says Carrie was friends with him. They went to the prom together. Okay, so there's already some misstatement of facts in here. Carrie is the friend of John, says Kimberly McGuire. I believe he took her to the prom. Thank you, Leanne Boylan. Melanie, I don't even know you, but since I started watching on YouTube, I feel as if I've known you for a long time. Thank you. You're absolutely incredible. Love from Boston. Thank you, my Boston friends. So notice how, and go back and watch my old streams on this. There's one stream that I did called Edited Witness Statements. I think that's right in the title. And we compared the witness statements and how they kept changing. Remember, this is months later. All of a sudden, Carrie Roberts is going to say, Karen Reed was hysterical and she screamed, John's dead, and then hung up. She called Roberts back and told her that O'Keefe had not come home. Okay, so now she called Carrie Roberts twice. That's the first time I'm hearing that. Let me know, my friends, if you've heard that before. That she called Carrie twice. During their conversation, she stated, something must have happened to him. What if he's dead? What if a plow hit him? Again, this is in the grand jury transcript. So the first time this stuff comes up is months later in May of 2022, when they testify in front of the grand jury after all of them have met with Adam Lally together as a group before their testimony. I don't know. Does that make you want to go, huh? The defendant also stated, I don't remember anything from last night. We drank so much, I don't remember anything. She never said any of this in her original statement. But you know what's funny about those original witness statements that were taken by Proctor and Buchanan? None of them were recorded. None of them were signed. None of them were videotaped, or even with one of those little, little pocket recorders. And now you can do it on your phone. But I mean, back in the day, we had a little dictaphone machine that we would carry around with us with these little tiny mini cassettes. Does anybody remember those? And you'd have people give a statement into that. But no, we don't have that here. All we have is this grand jury testimony months later and an unsigned witness statement that doesn't say any of this stuff. So if you know, you know. If you've been covering this case and you've been reading all the documents, you know this is all new information. But yet every single person says Karen did not appear drunk at all when we were at the Waterfall Bar. So let's go. Defendant McCabe and Roberts went to look for O'Keefe together at the Albert residence. While on their way there, the defendant wondered out loud whether she could have hit O'Keefe with her car and mentioned she had a crack in her taillight. Okay, there's no citation there. Oh, no, there is. Okay, so this is the grand jury transcript at page 148. I think it's about 1,400 pages, the grand jury testimony. While on their way there, the defendant wondered out loud whether she could have hit O'Keefe with her car and mentioned she had a crack in her taillight. So now it's back to a crack now. It's not shattered or smashed. It's back to a crack, and this is in the grand jury testimony. And it doesn't say, the judge doesn't say who said this, but somebody said this. Shortly after 6 a.m. on January 29, 2022, they arrived at the Albert residence where the defendant spotted O'Keefe lying in the front yard, covered in snow and unresponsive. When the paramedics arrived and asked what happened, the defendant, who was hysterical and inconsolable, repeatedly said, "I hit him, I hit him." And this is in the grand jury transcript at page 148. And we went over the original statements, and there is, I believe, an EMT on the scene, and her statement says, when I asked Ms. Reed how he got the injuries to his face, she said, "I hit him," as if she smacked him in the face or something. So this is out of context again, but I'm not surprised. We've read the documents. The judge read the grand jury transcript. The paramedics transported O'Keefe to the hospital where he is pronounced dead. The medical examiner ruled the cause of death as blunt impact injuries of the head and hypothermia. Blood impact injuries of the head and hypothermia. How did he get hit in the head by a car? I'm going to say this a little louder for those in the back. How did a 6'2" man get hit in the head by a car with no injuries below the neck, except for what looks like dog attack marks on his right forearm and some bruises or boxer fractures to his knuckles on his right hand? This is a good time to go over cause and manner of death, because this is going to come up in a minute. So let me just explain to you what cause of death means and what manner of death means. The cause of death is the underlying medical condition, disease, or injury that begins a lethal chain of events resulting in the death. For example, could be a heart attack. It could be, cancer. Manner of death is the way in which the death occurs. And there are 5. The manner of death can be homicide, suicide, accidental, natural, or undetermined. There are 5 manners of death that can be considered on a death certificate. We're going to get to that in a minute. So I'll keep that definition up there in my head so we can come back to it. So the cause of death is blunt impact injuries of the head and hypothermia from the cold. She did not see any signs, quote, any obvious signs of an altercation or a fight. And this is grand jury transcript at page 927. So it must have been the medical examiner's testimony in front of the grand jury. Again, I'm going to say this again and louder for those in the back. Those of you who cover true crime and or are medical professionals or lawyers or professionals that would ever read an autopsy report for any reason whatsoever can tell you that an autopsy report would not contain a statement such as, "I did not see any obvious signs of an altercation or a fight." Unless, of course, there were perhaps law enforcement standing over you while you were completing the autopsy who say, "We need to make sure that this wasn't caused by a fight. Can you put that in your report?" And I'm just saying, I don't know if that happened, but apparently some of you have pointed out to me, and it's been shown that this medical examiner did not have a lot of experience, may have failed her accreditation to become a medical examiner, may not have been as experienced as some others. What she also did not say is these injuries are consistent with being hit by a car or with a motor vehicle accident. These are just important little pesky details that I like to point out. During the subsequent police investigation, officers discovered pieces of a taillight and a broken cocktail glass at the scene. It doesn't say that the pieces of taillight were discovered during 5 undocumented searches, and the first pieces of taillight were discovered 10 hours later after something like another foot of snow had fallen on top of the snow. But we'll get to that later. And after the Lexus was towed back like 40 miles from her parents' house in Dighton back to the Canton PD, which had no jurisdiction at that point either. But, we are outraged. A forensic toxicologist, they seized the defendant's vehicle, which had a shattered rear taillight and scratches on the bumper. Yeah? Yeah? They seized the defendant's vehicle, which had a shattered rear taillight and scratches on the bumper. Well, yeah, no, because the tow truck driver said, no, it didn't have a shattered taillight. And did they take photos of the car when they picked it up at Karen's parents' house in Dighton? Which, interestingly enough, I've redacted it for you, of course. But the Commonwealth doesn't want, people wearing Free Karen Read t-shirts or even like Justice for JJ buttons at the trial. But the judge in this decision puts Karen's parents' address right in there for the world to see. So there's that. I redacted it for you. Don't worry, because I'm classy like that. So the grand jury was told that they seized the defendant's vehicle, which had a shattered rear taillight and scratches on the bumper. A forensic toxicologist opined that the defendant's blood alcohol level around 12:45 a.m. on January 9th, 2022 would have been between 0.13% and 0.29%. I'm going to tell you, and no, I'm not a forensic toxicologist, but I'm going to tell you this. It's a secret. That's a wide range. You can't now 0.13% to 0.29%. That's like more than double. So it's either this or it's more than double this. Okay. Let me tell you a problem about them getting her blood. I don't think her blood evidence, her blood alcohol evidence is even going to be allowed in to evidence, quite honestly. It wasn't taken at the scene immediately after the accident. It was taken something like 9 a.m. and it was only taken for a blood draw that was done at the hospital because somebody called the Canton PD and told the Canton PD that Karen was suicidal. So despite the fact that they told Kerry Roberts to drive Karen home or back to John's house, Canton PD was called and said, she's suicidal. You need to section her. Somebody called Kerry Roberts and said, bring her back here. We're not done with her. And then they put her in an ambulance and take her to the hospital, and they do her blood draw secondary to a medical diagnosis of she's suicidal. Not secondary to, we need her blood to show that she was drunk last night. So I don't know how any of this gets into evidence anyway to prove a drunk driving charge, not to mention she could have gone home and drank a bottle of vodka. So the whole thing is sus, but let's just go with that, because the chain of custody here and the way that they got this evidence and the HIPAA violations and all kinds of other stuff. Somebody said it's Karen's father who said she was suicidal. No, I don't think so. I know that that's out there, but somebody called Canton PD and said, I heard her say she's suicidal. You need to go get her. And I said on that stream, because we went over this, I said, where are those call logs? I want to know who called Canton PD and said, go get her. She's suicidal. We've seen her father on TV. We've seen him talk. We've seen him on TV. And after he did a courthouse interview the other day, do you think if his father thought that she was suicidal, that he would have called Canton PD and said, go take her to the hospital? Or do you think he would have went and got her himself? I'm not buying that part of the narrative. Sorry, Fairy Raven. I can't pull it up because I have you on my phone. So I don't know about this and how it's getting in, but let's just keep going because we're only on page 3. I'm going to have to speed it up. I know. Police officers spoke with the people who were present. Oh, here it says right here. The defendant's blood, footnote 2, was drawn at Good Samaritan Medical Center where she was taken after O'Keefe's body was discovered. Yeah, she was taken home. And then Carrie Roberts was told to bring her back because somebody called Canton PD and said, bring her back. And then they took her to Good Sam. So I got questions. Police officers spoke with the people who were present at the Albert residence, who all reported they did not see O'Keefe and he never entered the residence. There's your conspiracy right there. He didn't come in. Everybody say he didn't come in. A lot of people who were in that house, we now find out, did not testify in front of this grand jury. It was never disclosed that some of these people were even in the house until 8 months later. The Norfolk advocates for children interviewed O'Keefe's niece and nephew who live with them. They stated defendant and O'Keefe argued frequently. They both described a recent argument within 2 weeks of O'Keefe's death where he asked the defendant to leave, but she refused to leave. O'Keefe's niece described a second argument within a week of his death in which she heard O'Keefe tell the defendant that he wanted to end the relationship, that it had run its course, that it was not healthy. They argued too often. Again, I think she's 14 years old. The defendant did not want the relationship to end and again refused to leave the house. Okay, this I think is some new information. Okay. Officers also recovered text messages exchanged between the defendant and O'Keefe on January 28th of 2022. So that's the night before his death. And voicemails that she left O'Keefe on January 29th of 2022 after 1 a.m. We know that she walked into the garage and I think she was home by 12:41 a.m., correct? Leading up to the night of the waterfall, the defendant and O'Keefe exchanged several text messages about their strained relationship. Okay. In the voicemails that the defendant left O'Keefe on January 29th, she stated, "You are effing using me right now. You are effing another girl. You are a effing loser. F yourself." She called him a effing pervert and she yelled at him, "John, I effing hate you." See Grand Jury Exhibit 48. Taking that off the screen so I don't get stricken for foul language on my channel. But okay, if she intended to kill him like they're trying to say and she ran over him with her car and left him there to die, why would she be leaving him any voicemail messages? Right. Emmy said, if I killed someone, I wouldn't be sending them nasty voicemails afterwards. How many girls out there, and guys too, I don't want to discriminate, have left voicemail messages that you might regret sending later? We know they had been arguing something about the kids and that he was leaving the kids with her a lot. And maybe that's why she felt used. There was some alleged incident in Aruba where she accused him of cheating on her. Maybe that's what this was about. Who knows? But again, highly prejudicial, more prejudicial than probative. Will it be led into the trial in this case? I don't know. But this is what they led into the grand jury. And the defense's position is that there's so much here that you let in that you should dismiss the indictment. And we knew, don't get upset, we knew this was going to happen. It was going to be denied. Everyone knew this. We're just doing this so that we can look at the new information. So we went over the motion at length. We don't have to look at the legal standard again, but we know that we need to show. And she's going to say that prosecutors are, the case law says, prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. However, they must present exculpatory evidence that would greatly undermine either the credibility of an important witness or evidence likely to affect the grand jury's decision, as well as evidence, the withholding of which would cause the presentation to be seriously tainted. And then she's going to talk about some case law some more. And she's going to go to the discussion. And she's going to talk about all of these things that were admitted that she doesn't think would have led the grand jury to a different decision or a no bill, a no true bill, which would mean no indictment. But before that, let's go to the chat for a little bit. Yeah, also, I noticed last night when I was on Surviving the Survivor, one of the graphics said Karen Reed and her ex-boyfriend, John O'Keefe. And I'm like, why did they? I noticed that today. Somebody pointed that out to me. I'm like, why ex-boyfriend? It wasn't her ex-boyfriend. They were still together. No Strays Entertainment, maybe? ENT or ENT. Thanks for your super chat. So if I got this correct, the lead investigator, the DA, the judge, the Canton PD, the state police force, and the feds are all in on this. Got it? No, they don't all have to be in on it. They just all have to write down what some people are claiming. That's all. He didn't go in the house. If he didn't go in the house, and to you, I would say, Show me the evidence that she hit him with her car. Show me that evidence. Where's that evidence? Okay. The lead investigator, Proctor, is like a second family to the Alberts. We've seen evidence of that. Boston police officer Brian Albert's brother is Kevin Albert, who is a Canton police officer, which is why the Canton PD was conflicted off the case originally. And the ties run kind of deep. So I think you do. I think you got it correct. But I'm not saying they're all in on it. I'm saying they're going with what they were told from the witnesses, because that's the only evidence that you have that Karen hit John with a car is the eyewitness testimony that says, I hit him, I hit him, I hit him. Show me some tire tracks. Show me some injuries below the neck that were caused by a car. Show me a crime scene that was properly handled, that was roped off. In New York, when a police officer is killed, heaven and earth is moved to find out what happened. Guys who are on the job, who are off, that everyone comes in to find out what happened. Wasn't done here. It just wasn't done. Thank you, Cheryl, again. Thanks, Manny, for becoming a member. Thank you so much. Latina, thank you so much for your super chat. Hi, Melanie, please point this out. Lally said yesterday that the reason he had these meetings due to all the harassment of Turtle Boy. Those dates, Turtle Boy was either not reporting this case or in May 2023, just started to report. Lies. Oh, that's interesting. So is he going to claim now that there were some other people that were harassing all of these witnesses? That's a great point, Latina. Thank you. So Aiden, I prefer to call him by his given name. Aiden started reporting on this case in May of 2023. So all of these meetings, and coincidentally, wasn't that when the federal grand jury was sitting in April or May of 2023? That's when Aiden started reporting on this. So those meetings that he had could not have been due to that harassment. That is an excellent, excellent point. Thank you for that. Lily, thank you so much for your $10 super sticker. I appreciate you. And Latina says, Rule 17 for the grand jury. What? Federal grand jury. I don't know what you're referring to, but maybe we'll get to that portion. Thank you for another super sticker. And SanDB, thank you so much for your $5 super chat. Thank you for the truth and facts. You do your homework, unlike JC, who's too lazy to read the facts of this case. You blow her out of the water. Oh, listen, I don't consider her to be my competition at all. She's in a completely different area. And she's not a lawyer. So, apples and oranges, but thank you. I appreciate the comment. James Kelly became a new member. Congratulations, James. I think you're going to like it here. Cupcake and Mandolin Wim. Thank you so much for your super sticker and for participating in the chat and the comments, as always, with such great respect. Appreciate that. All right. So the first point here is that she's going to say why Sergeant Michael Lank's false and deceptive statements and conflict of interest don't really matter. So here we go. Let's see. Turtle Boy says, Jen McCabe applied for an order on me in June and was denied. A judge disagreed it was harassment. But I don't think Lally in his papers mentions you, but that's clearly what he's referring to, because it hasn't been made public if there were other alleged harassers of any of these witnesses. Yeah. So, I don't know. Thank you, little cupcake. Very old friend of mine who has stepped up to be a moderator on this amazing channel. Please remember to hit the like button. Thank you. That would be great. Helps the algorithm. It helps the case get out there. It helps people hopefully understand a little bit better about what's going on here. By reading court documents, by the way, and official police reports, etc., and watching hearings. The defendant argues that Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive on the scene on the morning of January 29th, 2022, gave false and deceptive testimony to the grand jury and withheld evidence of his personal relationship with the Albert family. Specifically, the defendant contends that the Commonwealth and Sergeant Lank gave false and deceptive testimony to the grand jury regarding purported admissions made by the defendant, and 2, gave deceptive testimony as to the reason the state police took over the investigation from the Canton Police Department, and 3, withheld exculpatory evidence as to Sergeant Lank's long-standing relationship with the members of the Albert family. Keeping in mind, Boston police officer Brian Albert, whose house Officer John O'Keefe was found on the lawn of, his brother is Kevin Albert, who is a Canton police officer, which makes Sergeant Michael Lank Kevin Albert's boss. Get it? Get it? Number 1, the defendant's statements at the scene. With respect to the first argument, Sergeant Lank testified. Okay, so we're going to learn what Sergeant Lank testified in front of the state grand jury that indicted Karen Reed. So officers that were there prior to my arrival had attempted to speak with Reed, but from what I had gathered from them, she was too hysterical and was unable to really assist us in any way. The only information they were able to retrieve from her is that she could not recall whether or not she had been there. And that is something he testified to at page 81. The defendant contends that this testimony impaired the grand jury proceedings because it was not based on personal observations, distorted the defendant's statements to the responding officers, and strongly suggested an admission of guilt. After careful review, this court concludes that the testimony does not meet the standard for dismissal. Surprise, surprise. To establish that the Commonwealth impaired the integrity of the grand jury, the defendant must first demonstrate that false or deceptive evidence was given to the grand jury, knowing or with reckless disregard of the truth. Nothing before the court suggests that Sergeant Lank gave knowingly false testimony to the grand jury, or that the Commonwealth sought to deceive the grand jury with the presentation of his testimony. Sergeant Lank clearly stated that his knowledge of the defendant on the morning of January 29, 2022, came from, quote, what he had gathered, end quote, from the other officers who spoke with Reed, not his personal observations. Then they cite a case that says that an indictment may be based on hearsay so long as the hearsay testimony is not used to deceive the grand jurors. Moreover, although other evidence presented to the grand jury demonstrates that the officers on the scene obtained more information from the defendant than stated by Sergeant Lank, nothing before the court demonstrates that those other officers communicated that information to Sergeant Lank, or that he purposely withheld it from the jury. Even if Sergeant Lank knowingly or recklessly gave a false statement to the grand jury, the defendant has not established that the Commonwealth presented a Sergeant Lank's testimony for the purposes of obtaining the indictment, or that it probably influenced the grand jury's decision to indict. I submit to you that in front of a grand jury, the testimony of a police sergeant carries a great deal of weight, and I would disagree with that. Even if he knowingly or recklessly gave a statement that it didn't influence the grand jury's decision to indict, I disagree. She reasons prior to Sergeant Lank's testimony, the three police officers who were first on the scene testified before the grand jury as to their firsthand observations of defendant and statements she made. Canton police officer Stephen Saroff described the defendant as, quote, very, very distraught, very upset. She kept loudly and hysterically saying, "This is my fault and I can't believe this happened," and asked several times if O'Keefe was going to die. Canton police officer Stephen Mullaney described the defendant as hysterical and distraught and repeatedly screaming, "Is he dead? And that's my boyfriend." Canton police officer Sean Good described the defendant as hysterical, continually yelling, "Is he dead?" Officer Good asked the defendant how O'Keefe ended up outside the residence, and she stated, "I don't know." He asked if she drove O'Keefe there the night before, and she stated, "I think so, and then I can't remember." He stopped asking questions because she was so upset, too upset, and she was unable to keep a train of thought. Given the preceding testimony of these three officers, okay, I'm breaking from this for a second, to tell you, none of whom say, "She said, I hit him, I hit him, I hit him." It is highly unlikely that the Commonwealth sought to deceive the grand jurors into thinking the only information officers could gather from the defendant was that she did not remember whether she had been to the Albert residence. For the same reason, it's equally unlikely that Sergeant Lank's testimony made a difference in the grand jury's decision to indict the defendant. Yes, and I see a comment here. Hold on. Mandolin Wind. But Jen kept suggesting that to her when she was in the car. Maybe you hit him? Hello, Cheryl, another one of my amazing mods. Cheryl Scott is here. Cheryl is here. Team Brittany is here. Hello. My mods are the best. Okay. Next point is the state police investigation. State police involvement in the investigation. The defendant also argues that Sergeant Lank gave deceptive testimony as to the reason the state police took over the investigation from the Canton PD. Specifically, the defendant contends that Sergeant Lank's testimony that the state police assumed jurisdiction and took over the investigation as soon as it was determined that O'Keefe was deceased, see grand jury at 98, was an effort to conceal the fact that the Canton police lost jurisdiction in the case because their agency was conflicted. See defendant's memorandum at number 17. Defendant has not shown that Sergeant Lank's testimony in this regard was false or deceptive, or he withheld exculpatory evidence. His testimony as to the reason the state police took over the investigation is consistent with General Law Section 38, Section 4, which requires that the Norfolk County District Attorney's Office, as law enforcement representative, here the State Police Detective Unit, directing and control an investigation of a death that occurs under the circumstances presented by this case. Which I submit to you is incorrect because Trooper Proctor was called into the investigation prior to Officer John O'Keefe being pronounced dead. So it was not yet a death case. But okay, go with that. Defendant has not put forth any evidence that suggests that the state police took over the investigation for some other reason. The defendant refers only to a Boston Globe article wherein Norfolk County District Attorney Michael Morrissey is quoted saying the Canton Police Department recognized a potential conflict early on and recused itself from the case. Okay, is anybody paying attention? Kevin Albert, the brother of the homeowner, is a Canton police officer. That's a conflict. That is a conflict 101. So I don't think you need a Boston Globe article to tell you that, Your Honor, respectfully. This article is neither competent evidence the court can rely upon for purposes of this motion, nor does it lead to the conclusion that Sergeant Lank falsely testified that the state police took over the investigation once it was determined that O'Keefe was deceased. Moreover, because the state police directed and controlled the investigation of the Canton police officers, and the Canton police officers testified only as to their involvement when O'Keefe's body was first discovered, it's unlikely that if the grand jurors had known the Canton police had a conflict in connection with the investigation, it would have any impact on their decision to indict. Then we're going to move on to their relationship with the Alberts. The defendant contends Commonwealth intentionally withheld exculpatory information that Lank has a long-standing relationship with the members of the Albert family, and that he in the past deputized himself to shield the Alberts from criminal liability. And then she'll go on to discuss that civil case against Lank from the 2002 incident when there was a bar fight. Sergeant Lank allegedly physically assaulted two individuals and had one arrested after they had an altercation with Tim Albert, Brian Albert's brother. Case later settled. Wait, was Tim Albert? Hold on. I got to go to the comments for a second. Who's Tim Albert? Thank you. Bev using Tim's name here when the significance of this connection is to highlight Chris, Colin's dad, and Lank's loyalty. This is the way the Commonwealth is downplaying the relationship. Right, that's what I thought. Chris is Colin's dad. Isn't he also a politician of some kind in Canton? In any event, the court is not persuaded by that argument. So we're going to move on. They're going to go through the definition of exculpatory evidence and that the Commonwealth's obligation to present exculpatory evidence needs to influence the grand jury's decision. And she says, even if knowing that Sergeant Lang had a history of friendships with Brian Albert's brother may have colored the grand juror's view of his testimony, Sergeant Lang was one of many police officers who testified before the grand jury, and his role in the investigations was minimal. His entire testimony makes up only 27 pages of the grand jury transcript, which is over 1,400 pages in length. Given the extensive amount of other evidence against the defendant, it's a little biased, isn't it? It is unlikely that disclosure of the withheld information would have affected the grand jury's decision to indict. Okay, so there's the first example of it. It wasn't so bad. I don't think that if the grand jurors knew that Sergeant Lang had a long history of friendship with Brian Albert's brother, and that, in fact, he was his employee, he was his sergeant. Shouldn't say that. Just going to talk about the case from 2002. 27 pages of testimony. No big whoop. Footnote number 3 says, to the extent that the defendant contends that the Alberts did not come out of their residence at the time O'Keefe's body was discovered because they were waiting for their friend, Sergeant Lang, to interview them, or a friendly, as I can't remember which attorney said in court. That assertion is purely conjecture. The testimony before the grand jury was that Brian Albert and his wife Nicole were sleeping during the early morning hours when the body was discovered. So that's how they testified in front of the grand jury. They were sleeping when the body was discovered. Moving on to Trooper Michael Proctor's false and deceptive statements and conflict of interest. They're saying, now the judge is saying that Trooper Michael Proctor co-led the investigation into Officer O'Keefe's death. Co-led it. He didn't lead it. Everything else says he was the lead investigator. Now he's co-leading. That he gave false and deceptive testimony to the grand jury, failed to disclose that he had a personal relationship with other percipient witnesses. Specifically, defense says that Commonwealth and Trooper Proctor, 1, withheld from the grand jury that Trooper Proctor is a close family friend of the Alberts. Number 2, failed to inform the grand jury that there was an alternate explanation for the defendant's broken taillight. And 3, withheld from the grand jury that the death certificate stated the manner of death could not be determined. Remember, manner of death, homicide, suicide, undetermined. Oops, what's going on there? As far as his relationships with the Alberts, defendant gave evidence that shows Trooper Proctor's sister was friends with Jennifer McCabe and Julie and Chris Albert, the brother and sister-in-law of Brian Albert. Footnote 4 says, to the extent that the defendant argues Trooper Proctor's relationship with these and other witnesses is closer than what is shown in the evidence before the court, such an issue is properly dealt with at trial on cross-examination. And that will be fodder for cross-examination, in addition to a lot of other things like the internal affairs investigation. Somebody asked me on the show last night, do you think that Trooper Proctor has to testify? And I said 100%. He's the lead investigator on this case. Without his testimony, the case is over. And his credibility is going to be shot already with all of these other things going on. The investigators the FBI and the feds investigating the investigation and the internal affairs investigation by MSP into his handling of this specific case. That's all coming in. And again, she says, even assuming that Trooper Proctor had a personal relationship with these witnesses, disclosure to the grand jury was not necessarily required because I don't think it would have changed their mind. Footnote 5 says, The court notes that there is an ongoing federal inquiry into the investigation of O'Keefe's death, and the state police is also currently investigating Trooper Proctor. The Commonwealth and the defendant have received numerous documents regarding the federal investigation pursuant to a TUI request, and the defendant cites several documents as evidence of a long-standing compromising relationship between Trooper Proctor and the Alberts. See defendant's supplemental memorandum at 5. The court has reviewed all of the documents from the federal investigation. Pay attention, because this part's important. She's reviewed all the documents from the federal investigation, and she says, the judge says, while they reveal several examples of Trooper Proctor's unprofessional and questionable conduct, right out the gate, she's calling Trooper Proctor's conduct unprofessional and questionable, according to several examples cited in the federal reports. The TUI document dump. There it is, folks. I'm not making it up. I'm not lying. It's right here in the decision. They do not shed much light on the extent of his relationship with the witnesses and what impact, if any, the relationships had on his investigation. At this time, no specific evidence cited by the defendant warrants dismissal. Okay, so she calls his conduct questionable and unprofessional, but as to the relationships, you can cross-examine him on that. Even if Trooper Proctor's familiarity with the witnesses suggests some sort of bias in the investigation that the grand jury may have considered, to warrant dismissal, the defendant must show the absence of the withheld evidence likely would have affected the grand jury's decision to indict. The grand jury heard extensive evidence supporting probable cause to believe the defendant struck O'Keefe with her vehicle. Therefore, even if the grand jury had been aware of Trooper Proctor's relationship with the Alberts, it would almost certainly have left unaltered the disposition to indict. Where's the extensive evidence supporting probable cause to believe that he was even hit by a car? I still don't have that evidence. I'm still waiting for it. I'm still looking for it. Here they talk about the alternate explanation for the broken taillight. Trooper Proctor testified that the state police viewed footage from ring cameras at O'Keefe's residence, including one camera located above the garage doors. The Commonwealth showed the grand jury the video, and Trooper Proctor testified as to what he saw. So we know now that the grand jury saw that video of Karen backing out of the driveway at 5:07 a.m. on January 29th, 2022, reversing out of the garage and driving off. They say, the judge says, as she backed out of the garage, her right rear taillight came, this is what Proctor says, extremely close to Mr. O'Keefe's SUV. No pieces of taillight were viewed anywhere in the driveway that day, and no damage was observed anywhere on O'Keefe's SUV. The defendant argues that this testimony was misleading because her vehicle did strike the SUV, breaking her taillight, thus providing an alternative explanation to the Commonwealth's theory that the taillight broke when the vehicle struck O'Keefe. Judge says nothing about Trooper Proctor's testimony was misleading. The Commonwealth was not obligated to offer an alternate explanation for the broken taillight. Nor does the fact that the defendant has a different interpretation of the video make Trooper Proctor's testimony false or misleading. Moreover, the evidence, the grand jury was allowed to look at the ring video, and they could have assessed themselves whether or not the vehicle made contact with O'Keefe's. Accordingly, there's no merit to the defendant's argument that Proctor's testimony about the ring video impaired the integrity of the grand jury process. O'Keefe's death certificate, which we have not seen, but we're going to learn a little bit about now. The defendant lastly contends the Commonwealth attempted to deceive the grand jury with its presentation of evidence regarding O'Keefe's death certificate. During the proceedings, Trooper Proctor testified that the cause of death listed on the death certificate was blunt impact injuries of the head and hypothermia. He was not asked and therefore did not testify that the death certificate listed the manner of death as could not be determined. Remember, there are 5 possible categories of manner of death: homicide, suicide, accidental, natural, or undetermined. Apparently, Officer O'Keefe's death certificate says undetermined. Defense is saying that was not pointed out to the jury. Judge is going to say, well, they were given the death certificate as an exhibit, so they were able to take that back into the jury room and consider it. But Trooper Proctor testified that the cause of death listed on the death certificate was blunt impact injuries of the head and hypothermia. He was not asked, and therefore did not testify that the death certificate had listed the manner of death as could not be determined. Didn't say homicide. According to the defendant, like Odell, the Commonwealth distorted the evidence by only presenting a portion of the information on the death certificate. This argument, too, is unavailing. She says that because the grand jury looked at the death certificate as an exhibit. Therefore, the medical examiner's conclusion as to the manner of death was not concealed by the Commonwealth. Accordingly, Trooper Proctor's testimony as to the death certificate did not distort the presentation of evidence to the grand jury. Here's where we get to Chris and Julie Albert's inconsistent statements. Oh, and here's what I was looking for, the footnote. The court notes that it is more likely that the Commonwealth did not elicit testimony about the manner of death because generally it's impermissible as evidence. Generally. I don't know if it would be inadmissible in this case because it'd be interesting to see when the death certificate was signed. Sometimes it takes months to get a death certificate. And if it was undetermined and not determined homicide, that could be a big piece of evidence in this case as well. What say you, my friends? What say you? Thanks, Sherry Davis, for your super sticker. Super chat. I look forward to eat her words. Thank you, Jam Jar, for your super sticker. I appreciate you. And Virginia Farizo became a new member. Congratulations. Welcome. Natalie McFeast. Thank you for your $10 super chat. Isn't there a phone call between Jen McCabe and Proctor the morning of John's death? I will leave that to someone else who has solidified those phone records, but I believe so. And I believe she may have called him and said, come back. I have more to tell you for your statement. Oh, Stephanie's been a member for 2 months and is telling me happy anniversary. Happy 2 months to you, Stephanie. Happy 2 months. It hasn't been that long since I started my own channel. I think I started posting my own content only in like July 23. 8 months ago. What a long, strange trip it's been. Next, Julie and Chris and Julie Albert's inconsistent statements. Defendant next challenges the testimony given by Chris and Julie Albert. She argues that Chris Albert gave an inconsistent statement regarding his presence at the Albert residence of the waterfall after the waterfall, and Julie Albert changed her story as to how she found out John O'Keefe has died. Now, the Commonwealth withheld both inconsistent statements from the grand jury. The court does not agree. So now we're going to find out what Julie and Chris testified in front of the grand jury. Here's how they testified. Before the grand jury, Chris and Julie Albert testified that they were at the waterfall the night of January 28th, 2022, but that neither went back to the Albert residence afterwards. Julie went home early with a headache, and Chris walked home when everyone left the bar. Okay, this is the first time I'm hearing that Chris walked home. Did anybody else say Chris walked home? Olivia, if you're still here, was this the first time you heard that? So we're learning now that that's how he testified. He told the grand jury that he walked home when everyone left the bar. Oh, I thought there was a raging blizzard outside and it was so cold. How far do they live from the waterfall bar? That's something else I want to know. If anybody else knows that, let me know that. Michael Breen, R.I.P. Jerry Garcia from the Grateful Dead. What a long, strange trip it's been. I miss Jerry every day. Still remember where I was on the day that Jerry Garcia died back in August of 1995. Still remember. So much for a blizzard. Drew says, new to me. Pure. First time I heard it. Maureen says, I never knew he walked home. I don't believe it. Rick Hamill always coming in with the comedy gold. Hosfar to walk home. Yes, please, someone tell me. Hosfar to walk home. Waterfall Bar to Chris and Julie Alberts. And I don't want you to dox their address. And look, I'm not. All I'm saying here is show me the evidence that Karen's car hit Officer John O'Keefe. That's all I want is that evidence. Because I'm hearing a lot of other noise out there. A lot of other noise. But I'm not seeing any evidence of a car hitting him. Oh, C-Rose says, Chris lives almost across the street. Okay. Awesome. It takes for Chris Albert to walk home. Yes, H-Bag, wouldn't John O'Keefe's family want to get to the manner of death changed to homicide if that's what they believe would happen? Yes, yes. Don't you think? And death certificates can be amended, and also sometimes you need a death certificate right away for things like estate purposes and, getting things distributed and things like that. But sometimes it takes a long time to get a death certificate. So yeah, I think that that's evidence. Yeah, Jen O. First time I heard that. I don't recall that either. Okay. So if he lived right across the street or close thereby, okay. But there were some other statements that said that he did go back to Fairview. So that is a change from an original statement because I believe we did read those original statements and he said he went to Fairview. Uncle Fredo. Hi, Uncle Fredo. Chris did not walk home. Robin says 5 or 10 minute walk. But I mean, I'm not crazy, right? Because his original written statement, or he didn't write it or sign it, and it wasn't recorded. But the original statement of him that someone took, however many days or months later, said that he went to Fairview. So yes, he did. And he lived on the same street as John, right? Earlier that month, he moved to John's neighborhood. Didn't they live on the same block? That's right. They lived on the same block. That's why there was beef, I think, because there were some beer cans thrown on his lawn, on John's lawn. By maybe Colin and his friends threw some beer cans on his lawn. Thank you, John Monagle. I knew I wasn't crazy. Chris and Julie, in their statement, they said that they followed back to 34 Fairview after the bar. Thank you. I knew I wasn't crazy. But now, apparently, he walked home. That's what he told the grand jury months later. Sergeant Buchanan testified as to his interview with Chris and Julie Albert on February 10th of 2022. Okay, so that's over 10 days after the incident, and where they both made similar statements. Similar, but not exactly. Similar. He didn't go home. He went to Fairview. So I think that's it. Defendant contends that Sergeant Buchanan's February 21, 2022 report memorializing his interview of the witnesses indicate that Julie and Chris Albert did go back to the Albert residence after the waterfall and that the Commonwealth intentionally failed to elicit Chris Albert's inconsistent statements before the grand jury. Defendant's memorandum at 24. Let's take a look at that footnote 8. The defendant refers to the report as Exhibit G. The defendant refers to Exhibit G in her motion. However, the defendant has only submitted to the courts A through F, so she's correcting the exhibit. Given that Chris Albert testified consistently with Sergeant Buchanan's February 10th, 2022 report that was read to the grand jury, it does not appear to the court that he did in fact give an inconsistent statement. The error appears to lie in Sergeant Buchanan's later report. Eliciting the inconsistency in Sergeant Buchanan's report would not likely have affected the grand jury's decision to indict. Oh, now she's deciding questions of fact. Now she's putting out there into the public domain that Buchanan is the one who made the error in his report. She's absolutely 100% here throwing shade on Buchanan's credibility, saying that he's the one who made the mistake in his report, and everything that Chris Albert said in front of the grand jury is true. What? Eliciting the inconsistency in Sergeant Buchanan's report would not likely have affected the grand jury's decision to indict. Accordingly, dismissal is not warranted based on this argument. Okay, so did Buchanan get up on the stand and say, yeah, it was my mistake? I wrote it down wrong? Because if that's the case, how can we trust any of Buchanan's reports? If he made a mistake in this witness statement report, maybe he made mistakes in all of them. Yes, John Monaco, Buchanan must be the scrivener who made the error. And now the judge has made a finding of fact that the error was in Buchanan's report. How can we trust any of Buchanan's witness reports? I know that there's a lot of twits out there that think I'm being paid by the defense, which I'm not. But if you're listening, that's a great tactic to use. How can Buchanan's reports now be trusted at all? If the judge has just said the error appears to lie in Sergeant Buchanan's later report. That's funny. Wow. He interviewed Chris and Julie Albert February 10th. His report was not rendered until February 21st, which is 11 days later. He didn't record the statement. He didn't have them sign a statement. He didn't handwrite a statement while he was with them and have them sign off on it. And now we're to believe that he made a mistake when he transcribed that report. So now I guess all of his reports should be disregarded. That. And she says even that is not good enough. Nor is dismissal warranted based on the defendant's arguments that the Commonwealth failed to impeach Julie Albert with her prior inconsistent statement regarding how she found out about O'Keefe's death. Julie Albert testified before the grand jury that on the morning of January 29th, 2022, she woke up at 5:50 a.m. and saw she had a missed call from Jen McCabe. She, quote, didn't think obviously anything bad, end quote, got out of bed, changed her clothes and headed. Okay. If you get a call at 4:53 a.m., let's just say let's just pick a time. You don't think anything bad happened? Who called at 4:53 a.m.? But she's going to say that she missed that call and she got up at 5:50 a.m. and saw she had a missed call and she didn't obviously think anything bad. And then she got out of bed, changed her clothes and headed over to the Albert residence to drop off a gift for her nephew's birthday. So she's going out of bed. She's going over to drop off a gift at 5:50 a.m. Here's her testimony at page 521 to 522. Upon arriving at the Albert residence, she learned of O'Keefe's death. Sergeant Buchanan read his report memorializing his interview with Julie Albert on February 10th, 2022, in which she gave a different account of the morning. She told Sergeant Buchanan that she was asleep at 4:55 a.m. on January 29th of 2022 when her phone woke her up and there was Jen's missed call, and that is how she found out about O'Keefe dying. But the court does not agree with the defendant that Commonwealth's failure to impeach Julie Albert warrants dismissal. First, the Commonwealth did not withhold Julie Albert's inconsistent testimony from the grand jury. Both her testimony and the statement she gave Sergeant Buchanan were before the grand jury. It is therefore not the case that the Commonwealth carefully scripted the testimony in order to hide the ball on the grand jury regarding Julie Albert's inconsistent statements. Moreover, even assuming Julie Albert falsely recounted how she found out about O'Keefe's death during her grand jury testimony, the defendant must show not only that the evidence was material to the question of probable cause, but on the entire grand jury record, the false or deceptive testimony probably would have affected the decision to indict. The court does not agree with the defendant's assertion that the difference in testimony clearly inculpates Julie Albert and exculpates Miss Reed. There's more than an inferential leap to conclude, as the defendant does, that Julie Albert's statement to Sergeant Buchanan suggests that she and Jennifer McCabe knew O'Keefe was dead before his body was discovered that morning. Highlighting the discrepancy in Julie Albert's testimony would not have undermined the value of other evidence tending to show that the defendant committed the crime. I put some arrows over here in the margin, probably because I disagree with that, or it's just another example of how this false or deceptive testimony probably would not have affected the decision. But again, when you add all of these things together, would it have affected the decision? Just like that now uncontroverted 2:27 a.m. search, or 2:22 to 2:27, I think are the exact times that Jen McCabe's phone made saying Haas long to drive to die in the cold. Island Girl, can't wait to see how they explain all their changed stories on the stand. Yeah. Snowcat Tish. This case is convoluted. It has so many layers. It makes my brain hurt. I know it makes my brain hurt too. Lacey Ant's like, I want to see the trial just for cross-examination. Oh, thanks, Cheryl, for putting my Venmo up. You know what I'm going to do? I can even make it even easier too. Let's see. Oh, look, there's the Venmo right there. Great way to help the channel because, you know, YouTube takes 30%. So all these people that think I'm making so much money from this channel, it's like it barely makes $49 a month it costs to, you know, buy StreamYard. But, you know, I'm very well paid apparently by the defense, as the twits keep saying. I wish, my friends, I wish. Okay, next, the introduction of propensity and bad character evidence. This is going to go to the Aruba evidence that we went over at length in one of the last streams. So apparently all this was presented to the state grand jury before Karen Reed's indictment regarding the trip to Aruba that occurred before a month before O'Keefe's death, where the defendant accused O'Keefe of having an affair. And two, the Commonwealth's presentation of hearsay evidence regarding the state of their relationship. And again, court says, no, sorry. None of that stuff was prejudicial. And I don't think that them presenting this stuff, the Commonwealth presenting this stuff to the grand jury, was enough to impair the grand jury proceedings. So there's no evidence before the court that the Commonwealth presented any false testimony with respect to the events that transpired in Aruba, or the defendant and O'Keefe's relationship leading up to January 29th of 2022, nor does the court find such evidence to be improper propensity evidence. May fly in front of a grand jury, it may not be admissible in the actual trial, so we will have to see. She says prior bad act evidence may be relevant in a grand jury presentation to show something other than propensity. In particular, prior bad act evidence is relevant to show a hostile relationship between a defendant and a victim to show state of mind and motive. The evidence presented here was relevant to the defendant's state of mind on the night of the incident and her motive to commit the crime. Okay, so let me get this straight. So she had a motive to kill him because of what happened in Aruba, that she wanted to actually kill him. She had the motive for murder, because that's what you're charging her with, is murder. Let me remind you, they were not married. She stood to gain nothing from his death other than losing a boyfriend that she loved deeply. So, not buying it. But yeah, let's throw in all this stuff about what happened in Aruba when she said F you to some girl that he hugged coming out of the elevator. I don't know. She says, because there was other evidence that apparently showed the strained relationship between the two, that it's unlikely that the events in Aruba were presented for the purpose of obtaining an indictment. Of course, everything that was presented to the grand jury was presented for the purpose of obtaining an indictment. How do you get away from that? How do you back away from that? That's what you're trying to do. The whole idea of a grand jury is to obtain an indictment. That's the whole reason you convene a grand jury. The court acknowledges, here, this in the footnotes, this is good stuff right here. The court acknowledges that the Commonwealth's presentation of prior bad act testimony with respect to the Aruba trip may have been excessive. And as a result, some of the evidence may have been more prejudicial than probative. However, looking at the evidence in its totality, keeping in mind the Commonwealth's relatively low burden of proof to obtain an indictment, think ham sandwich, and the defendant's heavy burden to show impairment of the grand jury proceeding, it is not evident that absent the prior bad act evidence, the jury would not have decided to indict. Citing some case law and some other things, she thinks bolster that statement. So right away, she's admitting may have been excessive, and as a result, some of the evidence may have been more prejudicial than probative. I think she's also giving us an indication of how she's going to rule about whether this stuff is coming in at the trial. But guess what? It's already out there. It's already out there for everyone worldwide who is watching this show. And to my worldwide viewers, my international viewers, raise your hand in the chat and tell us where you're from. Because while this was originally a Boston story and a local Norfolk County story, it has now become an international one. Somebody said earlier in the chat, and I didn't even star it because it was like, how come when Olivia is in the chat or Sean, you say that they can come on the show, but you never invite Turtle Boy on your show? And I don't know, there was something else in the rest of that comment. And here's what I'm going to say to that. I'm going to full screen myself to say this to you. Aiden, hi Aiden. I don't know you. I've never met you. We've never spoken, right? So all of these people on Twitter who think that I'm making up lies and I'm spewing, I'm one of your, I don't know, hires, followers, whatever. We have never met. We have never spoken. And I didn't know who Aiden was until I was covering this case and one of my viewers pointed out that he also covered this case. Okay. Or maybe it was a little bit before that when I was talking on one of my streams about wanting to cover it because I've been covering it behind the scenes. It would be foolish of me as an attorney to have someone on my channel or to go on someone else's channel who has a pending criminal case, who could potentially say something to implicate or to affect their pending criminal matter. And I would never put someone in that position. Okay. So everyone just take a step back. That would be very foolish of me to do as an attorney, to bring someone on my channel who has a pending criminal matter and ask them questions and have them give commentary when they could potentially say something that could affect their, I'm just not going to do it. I just don't do it. Okay. So let's just take a step back from that. All right. It's not my place to do that. So, I don't know what all the hubbub is about, but like, stop. Just stop. After everything is all said and done, I'm sure everyone will have a time to talk. But, yeah. Thank you. Thanks, Team Brittany. Oh, well, I thought you were talking to me. Yes, I did. Thanks, Lacey Ann. Big respect there. Everyone's got this. Yes, it's called ethics. Thank you, just Chrissy. I respect your choice. Yeah, it's not my position to do that. Everyone has this I don't know, fantasy that everyone on YouTube knows each other. We don't. Okay. Although I am going to be on Brian's channel tonight at 8:30. Because we did meet through this case and he's very kind to me and I'm very kind to him and we have a nice rapport. So come watch me over on LTL True Crime tonight at 8:30. But yeah, if Turtle Boy Aiden, I'm calling Aiden by his given name, Aiden, hope you don't mind, is in the chat, I'll highlight the comments. I am not going to jeopardize anybody's future by having them on my channel just so that I can get some clicks, some likes, because trust me, I'm too old to care about that kind of thing. Okay. So yeah, thank you. Thanks, Olivia. No, somebody put that in the chat, so I wanted to address it, and that's like where we're going with that. So, and that's it, and that's all I'm going to say about it. So yeah, there's that. Okay, let's get back to this because I do have things to do in my actual life. Although I love spending my time here with you, my friends. Also, they're going to say, the judge is going to say that hearsay evidence regarding the defendant's relationship with O'Keefe was not improper. So that doesn't warrant dismissal either. And the lay witness is an expert opinion. I thought this was interesting. There apparently was some testimony by State Police Officer David DeChico. First time I am hearing this name, State Police Officer David DeChico. Correct me if I have seen his name before in the documents. State Police Officer David DeChico testified in front of the grand jury that O'Keefe's brother stated that he went to the hospital to view O'Keefe's body and it looked like he had been hit by a car. Has anybody heard of police officer MSP David DeChico, who testified that O'Keefe's brother stated he went to the hospital to view O'Keefe's body and it looked like he had been hit by a car? First time I'm hearing this. Anyone? Bueller? Pierre is up on this case. New to me. Haven't seen his name. Okay, so there's a statement out there apparently from John O'Keefe's brother. Island Girl says, only wanted was for as many streamers as possible to cover this story. Thank you, Melanie, for your excellent coverage. Thank you. And I don't think that Aiden is upset that I'm not inviting him on my channel or he's not inviting me or whatever. Like, it's other people that are like, bah, 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 bah. Okay. David DeChico took a statement of John O'Keefe's brother. First time I'm hearing this. And says that he thought it looked like he'd been hit by a car. Again, hearsay, number one. Number two, there's a statement out there by John O'Keefe's brother. According to the defendant, such testimony improperly served as expert testimony. It was intended to substitute for the absence of testimony as to the manner of death. This argument is without merit. Again, the fact that they heard it from a state police officer might give it more weight, but it is a statement that allegedly was made by John's brother. Thank you, Olivia. Paul O'Keefe is not a qualified expert to be giving such an opinion, so shady for them to try and sneak that into evidence. Yeah. And they didn't call. Notice how they did not call Paul O'Keefe in. They had Officer DeChico testify about what Paul O'Keefe told him, which again, hearsay. But like, there's no rules of evidence in the grand jury. There's like really no rules of evidence. This is just, we're reading this so that we can glean all this stuff that we didn't know about that happened in front of the grand jury. And this is one of those things. She says, even if such a statement would be inadmissible at trial, which it would be inadmissible at trial, given the context of the statement and its relative unimportance in comparison to the other evidence before the grand jury, it's also highly unlikely that it was elicited for the purpose of obtaining the indictment or that it probably influenced the grand jury's decision. It's like the 10th thing in a row that had no importance, didn't influence the grand jury. But again, put all this stuff together. It's relative unimportance. It's the only evidence that points to Karen actually hitting John with the car because his brother said it looked like he got hit by a car, which is like hearsay. That it's offered to prove the truth of the matter asserted. That's what hearsay is. An out-of-court statement offered to prove the truth of the matter asserted. That's why it was offered, to prove that he was hit by a car. But again, not a lot of rules in the grand jury. Not a lot of rules. That's right. Then why offer that testimony? Because it was offered to prove the truth of the matter asserted. There is no other evidence. Right, Maureen, how would he know what someone looks like after being hit by a car? He was told by the police, your brother was hit by a car. You have to come identify his body. Like, that's what he's told walking in there. Right, Scott McGinnis. So Trooper gave hearsay statement from decedent's brother on the cause of death. No biggie, says the judge. Yes. Yes. It's also highly unlikely that it was elicited for the purpose of obtaining the indictment, or that it probably influenced the grand jury decision. Testimony from the McCabe's is our next section. The defendant argues that the Commonwealth elicited speculative testimony from Jennifer McCabe and her husband, Matthew McCabe. With respect to Matthew, the defendant contends that the Commonwealth asked him to speculate as to the reason defendant's car was parked outside the Albert residence for a period of time, but neither O'Keefe nor the defendant entered the residence. So this is a whole bunch of speculation. We looked at their Jennifer and Matthew McCabe's witness statements at length, how they kept changing their story about looking out the storm door. But here's what he testified to in front of the actual grand jury months later. Prosecutor asked how long the defendant's car was in front of the house. And Matthew said, the car was out there. We just thought it was weird, In hindsight, were they having a disagreement in the car? I don't know, I don't know why the car was out there, why it was parked there. It wasn't as if they pulled up and I looked outside and the next thing you knew, they were gone. They definitely moved the car and for some reason never came in the house. Okay, so she says, Matt McCabe offered that information up. That wasn't the question he was asked. He just volunteered that information. Therefore, it's okay that he said that. Doesn't matter. But in the footnote, says the grand jury heard testimony from Jennifer McCabe that after arriving at the Albert residence from the waterfall, she was looking out the window when she saw the defendant's vehicle pull up to the front of the house. Over the next 15 minutes, the vehicle remained outside the residence. Jennifer McCabe noticed that at some point, the vehicle moved to a different spot on the road. During this time, Jennifer McCabe texted O'Keefe and accidentally called him, but he did not answer. She further testified that at some point, the vehicle was no longer there, and she assumed the defendant and O'Keefe had left and gone home. I know there's some, I know that the phone records tell a different story. I don't have enough time to go over all of that tonight, but if you know, you know. Right, guys? Therefore, even if the question involves speculative testimony, given the other evidence before the grand jury, the defendant and O'Keefe had a strained relationship, were arguing that night. Matthew's testimony that he did not know if they were having a disagreement would not have made a difference. Well, it did make a difference because it's piling on the evidence that they were in an argument when everyone who testified who saw them at the bar said they were getting along just fine. Yes, there's a man passed out in the snow. That's what Jen McCabe said about her friend for 10 years when his body was found. She called 911 and said there's a man passed out in the snow. Not a police officer, not my dear friend, John O'Keefe. And didn't she also say 32 Fairview? Not 34? With respect to Jennifer McCabe, the defendant contends that the Commonwealth elicited speculative testimony as to why O'Keefe's niece described the defendant as acting crazy on the morning of January 29th, 22. However, this testimony was prompted by a question from a grand juror, not the prosecutor. And this is what the grand juror asked O'Keefe's niece. Oh, this is what the grand juror asked Jennifer McCabe about O'Keefe's niece. When you spoke to her, she said Karen was acting crazy. Do you know how long, or any information from your conversation with the niece, like how long Karen was there speaking to her, what she meant what she means by quite crazy. And the judge says, even if Jen McCabe speculated to the answer, it wasn't the Commonwealth asking that question, it was a grand juror. So it's less problematic. And then the judge says, the court notes that after the grand juror posed this question, the prosecutor asked Ms. McCabe, if you know, which apparently cures that, he was attempting to minimize the speculation. And then we're going to get to state police computer forensics expert Trooper Guarino's reports. Defendant contends that the Commonwealth put improper expert opinion before the grand jury when Trooper Proctor read reports from the state police computer forensics expert Trooper Guarino to the grand jury. Pursuant to search warrants, Trooper Guarino seized an infotainment system and a telematics system from the defendant's vehicle. Trooper Proctor read Trooper Guarino's report to the grand jury. Okay, so this is interesting. Because Guarino did not come in to testify in front of the grand jury. Why? Why didn't Guarino come in to the grand jury? Why did Proctor read his report? Is Guarino changing his opinion? Why wouldn't they just have him come in? They heard from, what did they say? Something like 42 witnesses? He wasn't one of them? That's interesting. And this is what I've kindly redacted for you. The actual address of Karen's parents, but here's the report. On Saturday, January 29, 2022, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk County District Attorney's Office responded to the unattended death of John O'Keefe, date of birth 12/8/75 at 34 Fairview Road in Canton. I'm going to break for a minute to say to you, Trooper Guarino's report says that Michael Proctor went to 34 Fairview Road. Michael Morrissey, in his what I call hostage video statement, said Trooper Proctor was never at 34 Fairview on January 29th of 2022. Am I right? Am I wrong? Isn't that right? Because here it is in the report. It's in the report. Through my investigation, he says, it was found that O'Keefe was a victim of motor vehicle homicide. Really? Because it's not in the death certificate. Homicide. Doesn't say what time. Sergeant Buchanan and myself responded to blank in Dighton, Mass. And secured Massachusetts registration blank, a 2021 Lexus GX570 SUV belonging to Karen Reed, date of birth blank. I've redacted all that for you because the court didn't want to. The vehicle was towed to Canton PD as evidence. Again, MSP has jurisdiction over this case now because Canton PD was conflicted out of the case. Why? Because the homeowner's brother was a police officer with Canton, right? This needs to stop. This needs to stop, Mandy. It needs to stop. Oh, by the way, my New York Rangers are going to the playoffs, babies. We're going to the playoffs. So, my streaming schedule is going to change. Last night, after I did the other show, I had to watch my Rangers win. So, we're getting into playoff season, baby. Okay. I digress. Sorry about that. But nevertheless, even though they were conflicted out of the case, they towed this vehicle all the way 40 miles, 37 miles, whatever it is in a blizzard, all the way back to Canton PD, right? So then on Wednesday, February 2nd, the vehicle was towed from Canton PD to the H7 Milton Barracks. 30 days, September, April, June, and November. So 30, 31, 1, 2, 4 days later. I supplied search warrant number blank issued out of the Stoughton District Court. The evidence was secured as follows. 1, infotainment system. 1, telematic system. At this time, we are unable to access the data and analyze it. Both systems are secured at the Norfolk DA's office for future analysis. State police also seized the defendant's cell phone and performed a cell phone extraction and forensic analysis. Trooper Proctor read Trooper Guarino's report concerning the defendant's cell phone to the grand jury. Again, why is Trooper Guarino not testifying? I have questions. It also stated through his investigation, it was found that O'Keefe was a victim of a motor vehicle homicide and concluded at this time we are unable to access the data on the phone. Again, if it's a homicide, why doesn't it say that on the death certificate? You're determining it's a homicide within 4 days later, and it's not on the death certificate. I want to know the date on the death certificate. Defendant argues that through this testimony, the Commonwealth side elicited improper expert opinion that Mr. O'Keefe was the victim of a vehicular homicide, falsely insinuating to the grand jury that he must have reviewed the electronic evidence in this case, suggesting O'Keefe was struck by a vehicle. Court does not agree with defendant's characterization of this testimony either. Although it may have been misleading, let's five an arrow there, it means important. Although it may have been misleading for the report to state, through Trooper Guarino's investigation, it was found that O'Keefe was a victim of a motor vehicle homicide. The report thereafter clearly states that the police were unable to access the data from the defendant's vehicle or phone. Okay. I've got a law degree and I've been a lawyer for 30 years and I'm confused by that statement. She says, therefore, it is unlikely that the testimony deceived grand jurors into believing that Trooper Guarino reviewed electronic evidence in this case, suggesting O'Keefe was struck by a vehicle. Even if, as suggested by the defendant, the opening sentence of the report may have led the grand jury to believe that the police had conclusively determined that O'Keefe was killed by a car, given all the evidence before the grand jury suggesting that the defendant's vehicle struck O'Keefe, this testimony probably did not influence the grand jury's decision to indict. Okay, I am definitely now in the twilight zone. What is all the other evidence before the grand jury suggesting that the defendant's vehicle struck O'Keefe? What is it? What's all the other evidence? I see no evidence. Again, one more thing that did not influence their decision. Then we're going to get to Jen McCabe's Google search, and the judge is going to say, guess what? They didn't have the version to celebrate then that they have now, which shows that the 227 search did in fact happen. Judge is going to say it. So they couldn't give them what they didn't have. So it wasn't misleading because it didn't exist at the time. But she says right here, indeed, based on an examination of the two reports, it appears that the more recent report used an updated version of the software, which included web history, data files, and activity sensor data that the previous software did not extract, because the Commonwealth could not have withheld information it did not have and was not aware existed at the time of the grand jury. The defendants has not established that the Commonwealth withheld exculpatory evidence from the grand jury for the purpose of obtaining this indictment. But it did happen at 227. It did. Now it's coming in trial. So again, all those out there on the other side, come to me and tell me why somebody would Google that. How long to die in the cold? Almost 4 hours before Officer John O'Keefe's body was found. And it wasn't Karen Reed that did it. It was Jen McCabe's phone. Maybe Jen McCabe didn't do it. Her phone did it. Somebody who had possession of her phone did it. 227. Again, I say, reasonable doubt. You know, like Vinnie Politan says, we're just looking for the truth here. We're just looking for the truth. We're looking for the truth. We want to know the truth. Why would somebody make that search at 2:27 a.m.? I feel like, I'm in the twilight zone again. Again, next thing. This is new. This is all new information. I didn't know anything about this. Tell me if you knew. Melanie Zabinajad. Somebody calling Melanie Zabinajad. I love it. It's one of my ranges. Wait, hold on. I got to highlight you. CC. The best Melanie Zabinajad. Thank you. It's a Rangers reference. Ranges. Olivia, how could their Celebrite version detect the 6 a.m. Google searches accurately, but not the 2:27 a.m. search? Yeah. You know, shield and a sword, shield and a sword. And I brought this up on Court TV and said, you can't use it as a shield and a sword and say Celebrite is so accurate in the Brian Walsh case, which is coincidentally in the same county, Norfolk. But again, in the Karen Reed case, not accurate. Here's the collusion alleged between Jennifer McCabe and Kerry Roberts. We didn't know about this. New information to me. Let me know if you know. Finally, the defendant contends that the Commonwealth withheld from the grand jury that prior to their grand jury testimony, Jennifer McCabe and Kerry Roberts wrote a timeline of events that occurred on January 29, 2022, and showed it to the state prosecutor. According to the defendant, by not eliciting testimony from these witnesses regarding the timeline, the Commonwealth improperly misled the grand jury into believing that Jennifer McCabe and Kerry Roberts testified to their own independent recollection of events that occurred on January 29, 2022. What? Jennifer McCabe and Kerry Roberts wrote a timeline of events that occurred on January 29th of 2022, and they showed it to the prosecutor. I want a copy of this timeline. Mr. Lally. But the judge says the court does not agree with the defendant that the failure to elicit such testimony undermined the witness's credibility and impaired the integrity of the proceedings. That two witnesses who are friends and who were with the defendant on the morning in question discussed the timeline of events that occurred before their testimony before the grand jury does not seriously undermine their credibility. Even if it may have been a better practice for the prosecutor to elicit testimony about their written timeline, the failure to do so did not seriously taint the grand jury proceeding. Holy what? Holy traveling Mary. It's another Meyer reference. And therefore, I am denying your motion. Hit the gavel on the thing. Motion denied. Thank you. Okay. Somebody tell me from the chat, two witnesses who are friends. Are Kerry Roberts and Jen McCabe, were they friends? Were they friends on January 29th of 2022? Or were they in separate friend groups where John took Kerry to the prom in high school and Jen was a friend from somewhere else? Okay. Kim O'Brien says, no, they were not friends. Kristen Pino, no, they were not friends. Maureen, no, they were not friends. But guess what? In this publicly published decision, now the jury pool thinks, oh, well, Kerry and Jen were friends. They were friends, of course. Why wouldn't they make a timeline? Why wouldn't they? Jen and Kerry were not friends, friendly, but not friends, not like Lank and Chris Albert. Nope, says Fairy Raven. Everyone says no, they knew of each other. They were not friends. Scott says not really friends at all. I know you guys are you live there. Yeah, right, Jennifer H. I bet 227 wasn't in that timeline. Before they testified in front of the grand jury, whose idea do you think it was to say, let's make a timeline, Kerry, so that we have the same timeline of events? I don't know. But that is weird. I've never known of anybody to create a timeline, little spreadsheet, little PowerPoint presentation to keep it straight in front of the grand jury. As I go back to the chat, because I have some things to do and I must soon wrap, but it has been so wonderful spending my afternoon with you. Lizzie Dalton, thank you so much for your super chat. Thank you, Melanie, for your measured reporting, truth, justice, and integrity. I'm trying to just shine a light on what I think is situation. Oh, thank you, Stephanie, for your Venmo. And Stephanie says, thank you for all that you do. Thank you so much. Oh, and Sandra B, thank you for your Venmo. Look at you guys coming in here. Sandra B, thank you for the Venmo. She says, hi, Mel, watching your stream today. Thank you for bringing the facts. Love it that you don't something which I can't read because it doesn't come up in the whole thing here, but thank you so much. Gotta thank everybody here because, my mom taught me to always write thank you notes to Leslie, also coming in here with the Venmo. Thank you, Leslie and Emmy. Thank you. You guys are awesome. You guys are amazing. Keeping the faith. Somebody bought me a matcha latte, which is my buy me a coffee thing without a name. Anonymous. Thank you, Anonymous. And thank you guys all so very much for watching and for appreciating. All right. So hold on. Thank you. Take that off. See if there's any pressing questions in the chat. But yeah, I think it's we've learned a lot today. We've learned a lot from reading these papers. Learned a lot about the meetings that happened between Adam Lally and a bunch of people. And they want the notes, and they're saying you can't have the notes because it's attorney work product. And we'll see what the judge has to do on that. And we read the motion to dismiss and why that was denied. But when you go back and watch the stream later, because I suggest that you do, because we really digested a lot of information today in 3 hours, you may come across some new information every time you watch it as you're reading, as I'm scrolling through the motion. And you may disagree. You may agree. What is my opinion? Ooh, Jed, my honest opinion, what will happen in this case? Remember that the motion to disqualify the DA and for sanctions is still out there. We did go over that at length. I feel like she's pushing this case for a reason. She really wants this trial to go on April 16th. We learned that it's probably going to be a 5 or 6 week trial. But it'd only be full days, Monday, Wednesday, Friday, half day. I think she said half day mornings, Tuesday, Thursday. And I don't know. We're waiting for a decision on that motion to disqualify. So we'll see what happens. I don't know that this case can go to trial on April 16th because that Bodie lab information, apparently, according to Lally, is not coming back until mid-April. So I don't know. Snowcat's like, I'm going to watch it again. My brain is mushy right now. I think all of our brains are really mushy. Juice man, no way a jury convicts. The 227 search alone simply cannot be explained. It's not one thing that makes no sense. It's everything. Yeah, I agree. I think there's tons of reasonable doubt here. I don't think there can be a conviction. But my thinking is like, is it going to go to trial? Is it going to go to trial at all? And is it going to go on April 16th? The next date that I'm aware of is April 12th, which is the final pretrial hearing. So I don't know if there's going to be motions that are going to be put on the calendar before then. Motions in limine, which are about evidence, which evidence is going to be excluded, which evidence is going to be excluded or included in the trial. Yeah, I don't think she's going to disqualify the DA either, Andrea. I don't know. I just don't see it. Based on all of the decisions that we've read already. Like, why is she now in civil court, but she wanted to hang on to this specific case? John says, Melanie, does it frustrate you when you go on shows with other experts who clearly don't know the details of the case, but have no problem pushing their opinions of what happened? Not really. Like last night, I found everybody to be so kind to me that I was very happy about that. And I'm happy to share what I know and to try and educate people and to try and let them know about this case. Because unless you've dove, unless you have done a deep dive into this case, nobody's going to know. It's just impossible to know all the details. So I'm happy to share what I know, and I'm happy to try and persuade people. I mean, that's what I do for a living, right? That's what lawyers do. It's a job of persuasion. And I find it interesting because the people who sometimes I'm on panels with are looking at me like, what? Like, that's part of the case. Like, I didn't know that was part of the case. Like, everyone heard right away there was video of Karen hitting John with her car. That's what they heard, and that's what they were told. And they were like, well, what is it? What's the big deal? Like, there's video of it. There's not. There is no video. So no, last night was fine. When I watch TV and I'm not on the panel, that's when it annoys me. When there's people talking about the case that know nothing about it. I'm like, what? Or if there's people out there spreading things that are not in court records that they somehow have a line to this information. Like, what? CC says, easy to tell the truth, preach the truth. Thank you. Thank you so much. Thank you so much. Dove, Divin. I just said, did a deep dive. Here's Black Rose, another one of my amazing moderators. Thank you, honey, for joining today. And you guys are really, really on top of it. And my moderators, I appreciate you so much. I don't really get to say it enough, but you guys are the best on YouTube. And Scott, I'm going to go back and watch the live chat from Surviving the Survivor last night, but I know that you were in there trying to yield some power, but apparently you had to be a subscriber for 30 minutes. And people said to me today, like, I hate that you have to be a subscriber. I don't have any money. I don't want to pay. Subscribing is free. Hit the bell, hit it right now. Right now, while you're with me, hit the subscribe button. It is free. Hit the bell so you get all notifications. Enable notifications on your phone. So when I'm going live, you will know. And you won't miss a thing. It's free. So you won't be notified unless you're subscribed. And sometimes you have to make the chat subscribers only because there are a lot of people that just want to come in and be mean and curse and say nasty things. And, you know, I think if people are subscribed for 1 minute, they're less likely to do that. I don't know if that really is true, but we'll see. Will they ever find and convict the real culprits? Unless somebody rolls over and is an eyewitness to what actually happened and can testify about it, it's been a very, very, very long time. So I don't know. I don't know the answer to that question. All I know is that Karen Reed's defense team does not have to prove anything. They don't have to prove anything. They don't have to prove who did it. All they have to show is that there's some reasonable doubt that she murdered him with her car. And based on everything that we know and everything that we've been through together, I think we can say there's a lot of reasonable doubt. They don't have to prove that someone else did it. And that's where so many of these twits are getting caught up in, like, well, you know, she can't prove that all these innocent people are being, you know, dragged through the coals and accused. No, it's just reasonable doubt that she didn't do it. And I would never advocate for anybody harassing anybody. I don't believe in that. And I'm not doing that. I'm telling you what's in the court documents. So that's that. But my moderators, you are the best. Thank you all. To my channel members who like me enough to want to subscribe to my channel. And that is a monthly fee. So that does cost money. But we do members only lives and we do some fun stuff together. And to my subscribers and my viewers who are viewing right now and all of my replay viewers, thank you so much for hanging out with me and giving me somebody to talk to and for talking back, because this is a channel that is collaborative. We like to talk to each other and we like to talk things out. And I don't always have all of the facts or all the info. And that's why you guys come in and you help me. And I love that because it is very collaborative. So thank you. Thank you so much. Thank you. Thank you. Thank you. Can't thank you enough. Okay. So hit the button on your way out. Canton PD will not get your DNA, according to Scott. He swears to that. And it doesn't hurt to hit the like button. So remember, my friends, to come tonight at 8:30 and watch me with Brian on LTL True Crime. And also, be cool, be kind, be classy. It is not hard, really. It is so not hard. Why does everybody think it's so hard? Peace. See you guys soon.